Subject matter is disposal. It has nothing to do with the trial. That was the argument advance, but on the basis of the facts, it is not disputed. It is admitted that it has been. So, if it is an admitted fact, Mr. Chakraborty, how do you prevent him? What we are saying is, please, Mr. Banerjee,
Yes.
please show the argument of the
Yes.
state. Mr. Chakraborty, the PP's argument. Read, that was the defense of the state.
লাগে তাহলে বলবো, যদি লাগে তাহলে this.
Mr. Chakraborty, tell us, is there any dispute as regards this fact that the sample was sent prior to certification?
Prior to certification, my lord,
It was not sent. This is not a disputed fact. It appears from the case that. Then 37, how your entire prosecution case fails.
Such fact is not in dispute.
The present application has been preferred. Such and such. Mr. Banerjee and the advocate appearing for the petitioner submits that the petitioner is languishing in custody for about 2 years, and that there is no possibility towards conclusion of the trial in the near future. And accordingly, on the ground of long detention, there possibility to stop. Mr. Banerjee further, drawing our attention to the
page 50.
Is this the FSL report?
Yes, my lord. Yes.
Drawing our attention to the FSL report as annexed at page 15 of the application, Mr. Banerjee submits that the sample was admittedly sent on 9th of September 2021. And the FSL report was issued on 9th of September 2021. And the FSL report was issued on 2nd August 2022. Stop. Prior to certification of the learned magistrate as peremptorily required under section 52-A of the NDPS Act. Stop. In view of such fact, further detention of the petitioner may not be necessary, and he may be enlarged on bail on any stringent condition. Mr. Chakraborty, learned advocate, learned APP, appearing for the state. However, disputes the contention of Mr. Banerjee and submits that the issue as regards
That's what I showed.
primary evidence. Yes, that goes against you, Mr.
Correct.
Chakraborty.
That is what I showed.
52A4 says, and this was quoted in Mohanlal.
Yes. Yes.
Mohanlal quoted
Yes.
that it is primary evidence. ওই মিস্টার ব্যানার্জিটা বললে না, in support of such contention, reliance has been placed upon the judgment delivered in the case of এটা কোথায় গেল ওই এই যে reliance has been placed upon the judgment delivered in the case of, give us the citation, Mohanlal, Union of India versus Mohanlal, na?
Yes, ma'am. Just, I'm sorry.
Judgment, give it to
Maybe
us.
judgment. ওটা SCC কে কোথায়? মানে 2016 3 SCC 379.
Union of India
Union
versus
of India versus Mohanlal 2016 3 SCC 379.
and another, 2016 3 SCC 379. Of the judgments delivered by the Honorable Supreme Court in the cases of Mohanlal reported in Ato and Simranjit Singh.
Simranjit Singh.
Is it reported?
No, my lord, it is just very recent. It's
And then unreported judgment delivered by the Honorable Supreme Court in
9th
the
May.
case of Simranjit Singh versus State of Punjab. Mr. Chakraborty বলেছেন যেটা কি বলেছেন? Issue as regards non-compliance of section 52-A of the NDPS Act. Is an issue to be decided at the appropriate stage of the proceedings. Such issue cannot be agitated at this stage. He further submits. Acha. Mr. Chakraborty has placed before us the case diary, wherefrom it appears that the Siliguri PS case number 1102/21 dated 21st July 2021. No, arekta para, Mr. Chakraborty further submits that that contraband substance above commercial quantity was recovered from the possession of the petitioner, and as such the statutory restrictions are clearly attracted. Stop, Mr. তারপর কি বলেছে drawing? Placed before us the case diary, wherefrom it appears that Siliguri PS case number such and such under such and such was registered on 21st of July 2021.
21st of July 2021.
No, it is 7th of September 20.
7 September. 7/9.
But you have recorded here Siliguri PS. No?
7/9, my lord, page 10.
25.
7/9/2020.
Oh, this is Siliguri 1, yes. You have given a wrong date here.
Bhaktinanagar police station case. Not
No, this is Siliguri PS case.
আরে FIR টাই শিলিগুড়ি।
Case record is of which Siliguri PS 1102 of 2021.
Page 10, page 10.
It's still.
dated 7th of September 2021. Stop. The seizure was on
7/9.
7th September 2021. Stop. Where is the application? Page, Mr. Chakraborty.
Page 30. Page 30, 31.
The application for certification of correctness of inventory, photographs and samples of seized narcotic drugs was filed on 9th of September 2021. And such certificate was granted by the learned judicial magistrate on 23rd September 2021. From the said sequence of facts, it thus appears, from the above sequence of facts, it appears that before sending the contraband substance for FSL examination, no certificate was issued by the competent authority as required under section 52A of the NDPS Act. Stop. Prima facie, it reveals from such sequence of facts, it is explicit that there are glaring lacunae in the prosecution case, which erodes its root. And in view thereof, it would not be appropriate to deny the petitioner's liberty at this stage, in spite of the statutory restrictions under section 37 of the NDPS Act. Accordingly, allow 10. Two sureties, 30,000. With a further condition that the petitioner shall immediately intimate the address where he would be residing to the inspector in charge,
Officer in charge.
of Bhaktinagar, Siliguri police station, and shall attend the learned court below on all the dates as specified for hearing. Intimate meet করতে বললাম। আচ্ছা, and shall meet with the officer in charge of the said police station once, inspector in charge of Siliguri police station once a week until further orders. The petitioner shall not tamper, or the petitioner shall also attend the learned court below on all the dates all the dates as specified for hearing. In the event of non-compliance, the bail may be cancelled without further reference to the court, disposed of. $30,000 each করে দিতে। এই যে সুভাষিস মিশ্র's book, you gifted to us. You should have struck out your name first then. Yes.
My lord, I beg to appear on behalf of the petitioner.
Habeas corpus,
Yes.
কি হয়েছে?
Petitioner is a resident of Assam, my lord. Petitioner brother on 3rd of July
Huh.
went to the residence of the respondent number 5 for purchasing a truck, my lord. The private respondent number 5 along with respondent number 6 and 7 illegally detained your brother and demanded a huge sum of money as a ransom, my lord. After that, complaint was supposed to be lodged by the father of the petitioner. My lord, on the day of lodging the complaint, my
Huh.
lord, before the concerned police station,
Huh.
respondent number 5, 6 and 7 was also present at the concerned police station. Accordingly, they went to the police station along with the brother of the petitioner. Then, my lord, the concerned police officer handed over the brother of the petitioner to the mother and made a video footage and of the scene by mobile phone and told the petitioner that the informant should leave the place. My lord, subsequently, without registering case, I came out of the police station, took my brother. On the way, my lord, while returning to Assam, my lord, again, my brother was kidnapped by the same set of persons. They came and took my brother. Again, they have demanded ransom. And till date, I do not know the whereabouts of my brother.
So where is the complaint as regards that fact to the police authorities? Show us the complaint.
My lord,
Ar ki milord? Where is the complaint stating the fact in paragraph 4 of your habeas corpus? Your story was after the initial complaint was lodged
Yes, my
on
lord.
14 July. They came and handed over your brother.
yes, miss.
And the next episode is when you came out of the police station, they again got hold of your brother and took him away.
Till date, my lord, the whereabouts are not.
So where is the
I do not
complaint?
know.
Where is the complaint to the authorities that this has been the fact that you are telling us? You are jumping the line.
Yes, my lord. My lord,
Tahle yes,
they are
my lord,
threatening
tahle
us with dire consequences. My lord, I went several times to the concerned police station. They
where
were-
have you stated that?
My lord, the police officers are unduly favoring the private respondents, my lord. And that
Mr. You, when you have a complaint, good, bad, indifferent, this is your grievance. Which person do you approach? The authorities, police authorities.
Yes,
To show us one scrap of document that you went to the police, submitted the complaint, they have taken no steps. Finished. Habeas corpus is for determining the validity in a summary manner to determine the validity of detention, custody or not.
now I'm before your lordship, my lord, direct them. to
There is no
produce-
cause of action.
They
Sir.
directs them to produce my brother, everything will be crystal clear.
But to
my lord.
lodge a complaint first.
My lord, my brother is kidnapped.
Yes,
my lord,
Mr.
1.5
Rahman, what is
months
your
ago.
My lord is exactly right. My lord, what happened in the initial stage after lodging of the complaint on 14th of July, the private respondents, that is the alleged accused persons, along with the alleged kidnapped person, were produced at the police station. They were handed over, my lord. And the petitioner also took possession of the said person, and they went away, my lord. Subsequently, no complaint registered. My lord, may I hand over the report?
To Mr. Rahman, he is in agony.
Yes, my lord, I can understand. Let him, my lord, at least approach the police station concerned. And I have been informed that there is a
You
commercial
are,
dispute involved.
huh? But if he has been, as rightly you have called them to the police station on the first occasion,
ma'am.
that where is his brother?
Yes, madam.
They immediately surrendered
He
before.
sent a hand and he was.
So what is have you dropped the case?
Yes, the particular.
You
case
did
was
not register a case.
It was withdrawn. It was withdrawn by the complainant.
Oh, the complaint was withdrawn.
Complaint was withdrawn. The complaint that was made on 14th of July, that was withdrawn by the complaint. Madam, kindly have a look at the report, madam. And the photograph is also there. That was withdrawn on consent.
Makes sense. And they will accept that. You don't have to go to the I think I'm living in the responsibility allow them to file the complaint.
Well, that is the withdrawal.
একটা অন্য evidence আছে না? আমরা jump করতে দিই। কি বলতে চাও?
কিন্তু অনেকদিন হয়ে গেছে তো, মানে জুলাই মাস থেকে
So Mr. Rahman, can ask your police to ring them up? No?
Lordship, I'll talk with the officers concerned. I will already inform them. And the fact remains that the current situation is that they have inquired, the police authorities have inquired, those persons who had the custody previously, those persons at present, they are saying that he is not with us.
Where you have stated that? In your
Well, that is the information that
that no case was
I received.
registered.
Well, that was the withdrawal that is annexed there.
কি বলবো? After that, no,
ইচ্ছে করে নিচ্ছে না,
না করেই না।
ওরা জিনিস করছে, ওরা কমপ্লেন করতে করতে আর নিচ্ছে না।
তুমি চেপে ধরেছো যখন বলছো। Where have you stated, sir, that you went to lodge a fresh complaint? Have you said that in your petition after 14th July?
Lord,
If there is, kindly appreciate, if there is no complaint, how they will proceed? If you file a complaint, we can ask Mr. Rahman that you treat it as FIR and conduct an
as
investigation.
per my instructions, Lord, the brother of the petitioner is still lying with the private respondent.
Have you served this copy upon them?
Yes, Lord. I have served it yesterday only, but it has not delivered. Lord,
Not delivered. See, Mr. Das,
yes,
you have two options.
Yeah.
Either you can withdraw the petition at this stage and file a regular complaint before the police, and if they do not do anything, then you can come back to us. Or if you say that no, on the basis of this you decide, in that case it becomes a bit problematic.
Lord, I have got two reference.
Or you wait, you effect complete service upon the private respondents and try your luck before the next bench.
Lord, two judgment may have placed, Lord, of Ramesh Kumari and Lolita Kumari reported judgment.
Lolita
Lord,
Kumari is custody.
Lord,
Lolita
but
Kumari is on registration of, where is that complaint made by you? Lolita Kumari, they are under an obligation to accept your complaint, but where is the complaint?
সেটাই তো বলতে হবে। কিন্তু রেজিস্ট্রি পোস্টে তো কমপ্লেন পাঠিয়ে দেওয়া যায়।
Lord,
Or do one thing, Mr. Rahman, he will go to your police station,
Lordship.
he will lodge a formal
Yes,
complaint,
Lordship.
huh? And on that basis, you
Yes,
take
I'll-
appropriate steps.
definitely, that will be done.
Lord, may I pray one thing?
Well,
Lord?
let him approach the police station. I have been informed. If he approaches the police station, complaint will be registered and action will be taken.
Complaint will be registered after 2 months.
Malad, he has not approached in the meantime. Malad, he has already.
Yes, what do you say?
Lord, one liberty may be given, Lord, to lodge a complaint.
Are
and
who is stopping you from lodging complaint?
expeditiously investigation may be
Saying on
completed.
record, I'm saying.
Nothing.
Lord, in the meantime, if something happens to my brother, Lord, I am under extreme pressure, Lord. Lord, if something happens, Lord, who is going to take the risk?
You go home, think about this matter and complete service and come back. If you are not agree to this, we cannot pass, we can dismiss the petition. But it is, you need to withdraw the petition and come back to us with better particulars. You can come back to us.
Then adjourn this matter till next circuit, Lord, on Monday.
Next circuit কিছু হবে না, you will not get that.
Lord, in the meantime, there will be served.
At least highly complaint. for the police station.
By that time, let him file.
Then Lord, direct the police, concerned police to.
Do not understand, I am repeating the same thing. Mr. Das, learned advocate appearing for the petitioner, submits that service upon the private respondents is not complete. Mr. Rahman, learned advocate, enters appearance on behalf of the state. Leaves the matter for further consideration. Oh.
In the meantime, may I
You,
approach the concerned?
Mr.
ডকুমেন্টস তো বলছিল যে সাপ্লিমেন্টারি
প্রথমে লেখো, Mr. Das, learned advocate appearing for the petitioner, prays for leave to file a supplementary affidavit. Stop. Let such supplementary affidavit be filed within a week from date. Stop. The petitioner is further directed to survey, intimate this order along with a copy of the, you have sent a copy of the
Yes, my lord,
petition.
petition already sent, my lord. Yesterday.
Let's say supplementary evidence filed within a week from date with a copy to Mr. Rahman. Mr. Answering our query, Mr. Das submits that service upon the opposite parties is not, upon the private respondents is not complete. In view thereof, leaves the matter for further consideration 2 weeks hence before the available circuit bench.
আর এগুলো কি written করতে with the record difficult দিয়ে দেবেন? যে ওনার তো-
আচ্ছা, ওই Mr. enters appearance on behalf of the state, let the report, as placed, let the report of the
My lord, officer in charge, Mexican police station.
officer in charge Mexican police station
My lord, it should be,
as submitted by Mr. Rahman
yes.
be kept on record.
My lord, may I get a copy of the report, my lord?
Huh?
May I get a copy of the report?
কিসের জন্য? ওই same thing has been stated.
ঠিক আছে। Very good.
That you go to Mr. Rahman.
কমপ্লেন্ট উইথড্র করে দিন তো ঠিক আছে।
Grateful, my lord.
Grateful.
করে দিয়েছে না?
Lordship, item number 3 kindly fixed on next circuit.
এই আমাদের কি দেখলে কত এই বিশ্বরূপ শুক্রবার কত দিন আছে mail and female?
Next circuit চলে গেলে আজকে আপনার বেরোনো লাগবে।
আমি তো 5:30টার সময় বেরোবো।
Next circuit চলছে।
তাহলে শুক্রবার কি করবো?
আমি ঘুরে যাচ্ছি।
যেগুলো mixer ফিক্সার তো দিয়ে দিতে,
হ্যাঁ।
যেটা not করে দিয়েছে খালি।
আচ্ছা, ঠিক আছে, next circuit।
ওই অর্ডারটা করে দেবেন, an adjournment has been prayed for on behalf of the petitioner, though Mr. Sikdar learned advocate, হ্যাঁ তাই তো?
Yes, ma'am. Yes, ma'am.
ঠিক বলেছি তো? হ্যাঁ, Mr. Sikdar learned advocate appearing for the state is present. Leaves the matter before the next available site. এই অর্ডারটাতেই ওই adjournment চাইলে এই অর্ডারটাই হবে।
Lordship, item number 4 also kindly fixed on next circuit.
Next circuit।
Or same order, or same order.
Next।
Mr. Sikdar, you are there in
Yes, yes, ma'am. Yes, ma'am. দিদি। একবারে দিদি।
কি আছে পিটিশনের নোট টুডে করে দেবেন? ভৌমিক দাঁড়িয়ে আছে তাও।
ফ্রিতে ছিল।
করবে না, কেন জানেন?
তো Mr. Bhumik, you are there, why did you take adjournment in 3?
Actually, the matter was filed on day before yesterday. We are not prepared to address your lordship.
You drafted the petition, how you cannot be prepared? Somebody else drafted?
No.
Then what? NDPS na 302.
One is 305, your lordship, one is NDPS. I'm very fairly submitting. So far 305 is concerned, that is initial stage.
5, who is in 5? You are there,
I'm in 5.
not today.
Your Lordship, the recorded law is out of town. I request you to give me time.
Next circuit।
Who is for the state? ওই স্টেটে ওই সৌরভ গাঙ্গুলির নাম দিয়ে দেবে নেক্সট সার্কিট।
Seven, my lord, I would like to not press the application.
Item
Item number 7.
on the prayer of the learned advocate
I'm going to state your question.
appearing for the petitioner, the application being such and such is dismissed as not pressed. Mr. Bhattacharya নাম দিয়ে দিয়ে উপরে
Item number 8. I'm the president. I'm for the petitioner. Your Lordship, in this matter, your Lordship, just to give your Lordship precious time, I want to draw such attention. Precious time, page number 16. It's a
Precious.
time, your Lordship. Already one co-accused got the privilege of bail.
My single bed.
Now, Lordship, can you see the page number 16? One of the co-accused standing on the similar footing got the privilege of bail by your Lordships. On the same date we are arrested, allegation against us remains same. Page number 16, your Lordship. Annex P1. There are 3 petitioners, 3 accused persons.
Page 55, 164 statement of the.
Maybe I am referring to page 16. Can you complete my part here?
Page 55.
Page 55.
164. All 3 accused persons, my lord, kidnapped the VG and then ravished him.
Where is the medical?
Medical
Evidence of
I thought no.
medical was exhibited, my lord. That's why.
that is the deposition of medical.
But you showed us the medical report.
My lord. Yes, ma'am.
The medical officer, we'll check it up.
My
Medical.
lord, 160, 172.
No, but anybody who this is
Handed over the deposition of the medical officer.
how long you are in custody?
I am in custody since your Lordship. 2 years, 3 months, 8 days.
26 April 2021, he was arrested.
2 years, 6 months.
3 months, 8 days. More than the person who got the privilege of bail on 30th August.
Show us the evidence of.
That is already handed over.
Page, I did not find it.
15th August के कारण turn line है। আমি তো দেখছি 15th August के कारण turn line है।
আগের ওটারটা।
हाँ, physics section is kind of turn down.
September 2021. Already detention has been.
Yeah, we are 30th August 2021.
Yeah, Mr. Sikdar, what is the difference between this Vishwadev and
My lord, actually, in this present case, my lord, all 3 accused persons are the principal. As because as per the version of the victim. 164 stated, as per the 164, she stated, clearly stated that all 3 committed an offense against her. And also, my lord, as per my instruction, he deposed as per the prosecution case, my lord, before the trial court. Doctor deposition already completed, victim deposition completed, complainant deposition completed.
Then why the medical officer is saying? That has come in the evidence, no?
But 164 is enough to.
One sixty-four does not say that the act has been committed. That and after 1 year, she was allowed to, after 1 hour, 1 hour, she was allowed to leave. This is under 376.
I am also gone through the previous.
The other person is still in custody.
No, my lord.
He is absconding.
No, my lord. One is juvenile who got bail from the
Oh.
Juvenile Justice Board. One from the, one got bail from this honorable court. And now the third one. This is the third one. 164 statement is there and it is very clear, man. Yeah, it's what it is.
Mr. Chakraborty, we granted bail to the other person,
Yes.
seeing the 164 and the evidence of the medical officer. The period was, say, her statement is 3 persons were there. You have seen the 164. এটা একটু দাও তো ওনাকে। Out of 11, 7 examined.
7 out of. Seven.
Out of 18, your lordship.
আবার কথা বল। Please take your seat.
Out of 18, not 11.
Mr. Bhumi, common learned advocate appearing for the petitioner, submits that the petitioner has been falsely implicated in the alleged offense. Full stop. The petitioner has been arrested on April 26, 2021. Full stop. The charge sheet has been submitted on June 23, 2021. A co-accused similarly placed with the petitioner has already been enlarged on bail. Full stop. Has already been.
Yes.
More than 2 years.
2 years.
ওটা তো একটা নিউ, ওটা ডিফারেন্ট। এটা কি হলো? Therefore, comma, further custodial interrogation of the incarceration of the petitioner may not be necessary. Full stop. Next. He also places reliance on the cross-examination of the medical officer who has deposed that there is no injury in the private part of the petition, as well as on any other part of the VG. Next. Mr. Shikdar, learned counsel appearing on behalf of the state submits that there are several incriminatory documents against the petitioner, and considering the gravity of the offense, the prayer for bail should be refused. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, prima facie, this court is of the view that the statement made by the victim girl under section 164 of the CRPC reveals inconsistencies with the statements made in the FIR. Full stop. The medical report also does not corroborate with the statements made in the FIR. Full stop. Prima facie, the medical report also does. Next. Upon completion of the investigation, a charge sheet has also been filed on April 26, 2021. Full stop. The evidence of the victim girl is also complete. Full stop. Next. Considering the long period of incarceration of the petitioner and the fact that the evidence of the DG is complete, this court directs the petitioner to be released on bail on the following conditions. 10,000 two sureties, 1 local, to the satisfaction of the additional sessions judge, second court, Jalpaiguri. Further condition that the petitioner shall not enter the jurisdiction of Hon'ble police station where the VG is residing, and shall also attend all the scheduled dates of hearing before the trial. Full stop. Next, the petitioner shall also meet with the officer in charge, Malbazar police station once a week until further orders. He resides in the Malbazar police station. All the petitioners residing at the same place. না ওটা বলে দিয়েছি ময়নাগুড়ি এন্টার করবে না ফেসিলিটি অফ ময়নাগুড়ি হ্যাঁ এটাও বলে দিয়েছি ওটা আগে বলে দিয়েছি
এটা ওই ম্যাডামের ফাইলটা
Pardon? Next date fixed for 3:30. So trial has been total evidence is complete. Full evidence is complete.
So only arguments are required.
My lord, kindly say that the evidence is completed about 6 months back. My lord, thereafter
Next date at 4/10/2023, my lord.
already the date already elapsed for 3:30. But my lord.
Why they were not produced? 313,
My lord, I custody. Examination of the actual, my lord.
So why 3 dates given?
2020. It is allowed for 3/3. I'm not done. The accused is not influential part, sir. There is no chance.
When is the next date?
Fourth of
October.
4th of October.
2020. My lord, I am custody 1 year, 8 months. 30 rupees.
302 is there, madam. The three accused is there. All are in on custody at time, madam.
My lord,
Acha, show us when was your application last rejected? Did you approach this court earlier?
70.
High Court was approached.
No, my. 7.
In
Seven.
July, Mr. Chakraborty, the case was in the stage of examination of 313 in July. Allegation to ফোন করে আমার স্বামী যেমন আমার সঙ্গে আনুমানিক জাস্ট আমার গেট খুলতে বলে আমার স্বামী
When election will be passed, my lord. Accountancy. Not any other.
they will complete it. We are directing. If it is not completed, we grant you the liberty to approach this court.
No, but it's defined as 2 days. Therefore, अपना timing should be reasonable.
When is the next date, Mr. Chakraborty?
4th September.
4th of October.
4th October 2023.
The present application has been filed such and such. Mr. Such and such learned advocate appearing for the petitioner submits that the petitioner is languishing in custody for about 2 years.
My lord,
No.
1 year, 8 months, and 13 days.
And when did you file it?
23rd December 2020.
Is in custody for about 1 year, 8 months. 1 year, 8 months, stop. Upon completion of though the 1 year languishing custody for such and such, stop. Though all the witnesses have already been examined,
30 March,
Uh,
30 March 2005.
adjournment was taken thrice.
My lord.
Though all the witnesses have been examined, all the witnesses have been examined, and the case is in the stage of examination under section 313 of the code. He, however, next paragraph, he, however, submits that he, however, submits that 3 dates have been taken, that 3 adjournments were, he, however, submits that repeated adjournments were taken, and the examination under 313 could not be completed. Stop. In the said conspectus, further the delay is attributable to the state. Delay is attributable to the state, and in the said conspectus, further detention of the petitioner may not be necessary. Mr. Chakraborty, learned APP appearing for the state, opposes the petitioner's prayer and submits that the next date has been fixed for examination under section 313 of the code on 4th of October. Mr. Opposes and submits that all the witnesses have been examined. And date has been fixed for examination under section 313 on 4th 10/20/2023. Considering the stage of the trial and the gravity of the offense, the petitioner's prayer needs to be refused. Having heard the learned advocates, we have heard the learned advocates and considered the materials in the case. Heard the learned advocates and considering the materials in the case diary, the gravity of the offense and the stage of the trial and the stage of the proceedings, we are not inclined to exercise discretion in favor of the petitioner at this stage. However, we direct the learned court below to expeditiously conduct the trial and conclude the same. We are giving 4 months, Mr. Chakraborty. Conclude the same within a period of 4 months from date, without granting any unnecessary adjournment to either of the parties. It is made clear that in the event the trial could not be, proceedings cannot, in the event our proceedings are not completed within the above period, due to the laches on the part of the prosecution, the petitioner would be at liberty to renew his prayer for bail. With the above observations and directions, the application is dismissed.
In the month of October, there is a vacation of puja vacation. So that period could be 4 months, but that inclusive. So 5 months, man.
5 months. No, disposed of.
Grateful, man.
5 months. Yes, next.
My lord, I am for the petitioner, my lord.
I am for the state lordship.
My lord, a very short issue, my lord. I will not trouble your lordship much, man. I am an accused in a case under the 14th Foreigners Act. Right, my lord? I am in custody for the last 1 year, 9 months.
No, just one minute.
Right, my lord, right.
Yes, Mr.
Yes. Now, my lord, I have been an accused in a case under 14th Foreigners Act, where your lordship may be aware, the maximum punishment is 8 years and the minimum is 2 years, and more or less a 1 year, 9 months in custody. Now, my lord, the question here is, which I would like to place before your lordship is, my lord, this gentleman who is in custody was being persecuted in Dhaka, being a member of the opposition party in Dhaka. So he fled away and he was caught on a motorcycle when he entered into India. Right, well, we moved a writ application before this court, and in this court we asked that United Nations for asylum, we moved an application before this court. Now, the question is, my lord, when it comes to a prayer for asylum, you have to be physically present before the United Nations Info desk in Delhi. Now, my lord, what I'm praying for is not the bail in the sense that, my lord, I should be given the liberty of bail in its entirety. What I'm praying before your lordship is a 1 month window for me to go to Delhi, make the payment, and then go back to custody. This is the main thing, my lord, I was trying to impress upon your lordships.
But
My lord, yes,
Mr.
my lord.
Mukherjee, that prayer has been refused in the writ petition.
No, it is said, your lordship, my lord, please comes to the
Page
prayer in the
18.
writ petition was go for bail.
No, page 18 is the order, Mr. Mukherjee.
Yes, of Justice Mantha, my lord.
Court does not want to exercise jurisdiction.
No, that's true. My lord, please comes to page 17, my lord, for a minute. Page 17, first line.
Yes.
The petitioner himself was Indian, so and so. That is the elder brother of the petitioner.
না পিটিশনে তো প্রেয়ার হয়েছে আমাকে বেল দাও আমি অন্য জায়গায় গিয়ে এক মাসের হিন্দুকে দেয়নি নিশ্চিত করে দিতে হবে চান্স আছে না এখানে প্যারাগ্রাফ 9 বলেছেন আমার রিলেটিভ আছে Yes, sorry, Mr. Moody. Yes.
No, it's all right. My lord, please comes to page 17. My lord, Justice Banerjee will also come to that. Page 17, my lord. The petitioner himself, well, he's the elder brother of the petitioner before your lordship, has entered into India on a valid visa. It is submitted that the petitioner is required to take his brother from prison to New Delhi to approach the United Nations High Commission for necessary protection for declaration as a status of a refugee. Now, on the next page, if your lordship sees, for the aforesaid purpose, it is stated that the petitioner husband brother who is languishing in prison is required to be taken physically to New Delhi. Then, when a judgment is given, then, my lord, the observation of this court is of the clear view that what cannot be obtained directly under the provision of the CRPC cannot be obtained indirectly under Article 226 of the Constitution of India. It is, however, true that the powers of the High Court under Article 226 of the Constitution of India are extremely wide, and Article 21 of the Constitution is available even to foreigners. However, I'm not inclined to exercise my power. But what I'm trying to impress upon your lordship is the factum that I've applied for refugee status is a factor which is there on record. Now, unless I physically go there, it will not be possible for me to appear before that. That's an admitted position in the writ petition also. So, my humble prayer was, if a window could be given to me in the form of an ad interim bail for a period of 1 month, so that I can go to it and come back and go back to custody.
But Mr. Mukherjee,
Yes, my lord.
the case which you have made out here is that give me bail, as there is no question of fleeing from justice. I will reside in my relative's place at home.
Native place in Hon'ble.
We can consider such prayer of yours. We can consider such prayer. But
Yes,
how
madam.
can we give a window that you go there? If we
No,
grant
madam,
a bail in
your
your
lordship
favor,
may not, madam, I cannot tell your lordship to write that. What I'm trying to tell your lordship is, I
Yes.
cannot say that, but this is my
No.
submission before your lordship.
No.
But your lordship's grant of bail in a Foreigners Act is a very dicey situation. Your lordship has to accept that, but at this age of 40 years of practice, but I won't say something to your lordships, which may affect me also. So what I'm trying to impress upon your lordship is, I have prayed for bail. I have not prayed to say what I'm saying to your lordship today. Only thing is, my lord, your lordship doesn't make the if an interim order can, I've already served out the minimum sentence. I've already served out the minimum sentence.
You are in custody for how many
From
years?
January 22,
22.
1 year, 9 months. 2 years is the minimum punishment.
Yes, what do you say?
Lordship, I'm strongly opposing the bail application. He's a BD national. He cannot stay in India. If he's released on bail, Lordship, there will be a repetition of the offense under section 14A of the Foreigners Act. The moment he steps out from the jail, he will commit another offense under the same section.
Why we will say that because he has to avoid persecution, he has come. So in all probability, he would not venture to go back to Bangladesh.
Lordship.
Had it been a case that he will leave the territory of India, if 14C was there, then there would
Correct.
have been this opportunity that possibility that he would immediately go to another state. We cannot catch him and we cannot complete it. But please consider that he has given a particular address. We can verify the address and we can say that you have to remain, you cannot leave the jurisdiction of that court. On that condition, what is your submission to them? This is just we are thinking because the person has undergone detention, charge sheet and everything has been completed. So you are thinking that if we leave him, then he will commit another crime.
He will commit the same offense. The moment he steps out from the jail, Lordship,
Yes.
there is another way. He's not entered into the country without a valid document. He will commit the same offense.
I
once he
think,
steps out.
Mr. There is a central government circular that if a person in view of such persecution has shifted the territories, in that the provisions of Foreigners Act would at all apply or not, that is within the domain of the central government. That is a September 2015 memo, I think, subject to correction.
Yes, my lord. Your lordship is right. My lord.
That is another limb of the submission. But
Lordship, give us 1 day. Lordship, give us 1 day time.
Friday. Friday.
সেটা ফরেনার্স অর্ডার যেটা আছে সেটার কনসিডারেশন দেব গ্রাউন্ড ছেড়ে মানে we are granting him opportunity to stay contrary to section 4. Without valid
Lordship, give us 1 day time, we'll come back.
Friday.
No.
Information to me, which information to me.
Friday.
There is no treaty between Bangladesh and India for political asylum. As per my knowledge, madam.
No, that
So
is,
without
we
that,
are not granting asylum.
This type of foreigner cannot be political asylum.
He cannot stay in India.
Cannot stay. There was a treaty with Pakistan. There was a treaty with India. That's why.
That is an issue to be decided by the United Nations Council. That is their jurisdiction. But today, Mr. Chakraborty he has undergone a particular period of details. What he's submitting is, he's right that today if you grant bail, that will be again contrary to section 14A, that he would be allowed to.
Only pushback provision is there, madam. So how can madam? This is the question of, I'm putting this question myself.
Mr. Mukherjee, what is your answer to that?
My lord, the answer to my learned friend that as soon as I get out, I am liable for another offense. But I am totally in agreement with him. There's no second opinion on that. But let's be very honest, my lord. Your lordship trusts me, and I think my learned junior friend trusts me. The only issue here is, my lord, as my lord has said about the 2015 circular, pertaining
No,
to the
that
fact
I am not aware. That I am not.
No, I'm aware of it, my lordship. So once I can send it to your lordship, to my junior there. And the second part is, my lord, I will refer to 2 judgments where Burmese refugees, my lord, were given 1 month bail two months bail to go to Delhi and play for their refugee status. But I have the two judgments, my lord. If your lordship so desires, I can give that judge. হ্যাঁ, জানি, দেখছি, দাঁড়িয়ে আছে। Well, let me say for argument's sake. Or jurisdiction.
Mr. Chakraborty, have you seen paragraph 9, where he would be residing?
And Hooghly, my lord.
This is of Hooghly. This is of Hooghly.
And I've given his Aadhaar card and everything as a part of the annexes.
Khanakul PS. So we direct your officer in charge to file a report before us as to whether this petitioner is a permanent resident there, as to whether he has property or not. Come back to us, then we will consider.
Right.
What is your submission? We have not granted the bail. We are seeking a report from you.
Maybe his relative, he or she is in Indian citizen.
Yes.
Holding the house of the concerned PS, my lord, but is not.
We have not granted bail. No, Mr. Chakraborty, we are not allowing
make
this
a
player
report.
for bail. We are only directing that since a pleading has been made, that if we grant bail, he will reside there. Whether that person has residence there or whether he has landed property, then you can come and tell us.
Correct. I'm grateful, my lord.
Heard Mr. Mukherjee, learned senior advocate appearing for the petitioner, and Mr. Chakraborty, learned advocate appearing for the learned APP appearing for this case. Stop. This is which PS, Mr. Mukherjee? Hooghly, which
Khanakul.
PS?
Khanakul, I think. My lord, Khanakul PS, my lord.
It has heard such and such. It has been submitted on behalf of the petitioner that in the event he is granted bail, he would be residing with one Sheikh Maqsadul, son of Mahiuddin, who is his relative and is residing at Udna, Balipur, Khanakul, Hooghly, pin 712401. Stop. This court directs the officer in charge of Khanakul PS to file a report before this court on the returnable date, verifying that returnable date, file a report as to whether Sheikh Maqsadul is residing in the address as stated above, and as to whether he has any landed property. Stop. This is the matter for further consideration. When can you come? Certainly. We have comprehensively, we are not giving. You file a report, automatically you file a report on the returnable. List the matter for when can your officer file, Mr. List the matter before the next available. Huh? No, we are specifying a date. next circuit, we will subject to the convenience of. আচ্ছা ঠিক আছে list the matter for further consideration on before the next available circuit on 18th September, comma subject to the convenience of the honorable bench. Yes.
Well, nowadays in this, well, mobile and everything, well, everything could have been done in a day. Because I didn't want to miss your lordships, my lord. Justice Banerjee and your lordship, I didn't want to miss the lordships. Grateful, my lord, grateful, my lord.
Grateful, my lords.
Mr. Chakraborty, you look into that and your argument as regards what is being settled, come with appropriate.
Well, I must be honest with everybody. Grateful, my lord.
Yes, next.
Lordship,
Yes. Yes.
yes, Lordship, kindly fix the matter on 8th September.
We had been so kind since the morning. We do not want to be further kind.
Because the certified copy of memo of arrest will not yet to be received.
That your friend has. Your friend has that copy. What, NDPS?
Lordship, in spite of my submission of yesterday, she is
Yes.
taking time. I am not.
Lordship, kindly 8th September.
আবার বলে kindly. He is going to be kind with you. দেখি ফাইলটা দাও। What is your name?
Deepika Pal,
You argue. Yes.
Advocate on record.
advocate on record.
Very good.
I have not filed your Lordship, I have. not
All right.
filed.
If we hold against you, we will adjourn. Let us see. Yes. Yes. No, Mr. Ganguly, is it a case where it can be, this is
Lordship,
NDPS?
the Lordship can be taken as because the petitioner was arrested on August 2017, that is 6 years in custody.
ওরে বাবা।
I was only the investigation of the examination of the investigation officer is there. He was four times summons and last warrant was issued against him. But we have a positive point, that is his examination chief is over. Now cross was deferred by the affair.
How many witnesses are there?
Lordship,
13.
13 witness, PW 8 is the investigating officer.
So 7 has been completed.
And another point is that if Lordship sees it for Lordship's consideration, as because she is moving the same, I am placing that record. Anand Taman. Lordship, if Lordship can you see this, this is the arrest memo what which she was stating.
Memo of arrest.
Memo of arrest that the person who signed is not the respectable person of the locality, neither the relative of the petitioner. Is the police constable.
Oh, column 10, it
Column
is
10.
Devashish Saha. One Devashish Saha has signed. It is blank or somebody has signed.
No, Lordship, there was a column 10. Column 10 is Constable 1161 Devashish Shah. Constable 1161. The police constable.
That is his ground in the.
He has taken it, Lordship. Lordship kindly
So
see,
he is saying that a constable is not a respectable member.
no, of the locality where they, as per what you, I have to submit this going on their side, Lordship, but for to assist the court. 41B says, Lordship, in view of the orders of DK Basu, the person has to be a respectable person of the locality where the seizure took place. In para 3, she has taken the plea. Now I'm playing 12 Standing in this side is, I should not.
When was his prayer last rejected?
কবে রিজেক্ট ব্রিফটা কোথা থেকে? এর আগে ওকে এনএক্স করেছো মানে হাইকোর্টে নিয়ে চলো হাইকোর্টে হাইকোর্টে হয়নি লর্ডশিপ ইট ওয়াজ নট রিজেক্টেড ইন হাইকোর্ট হোয়াট শি সেজ যদি yes 6 years now I leave it up to the court.
What was the quantum of
Quantum is very, it goes against
one
one kilo 155 grams of chorus. So that goes against her.
any single person?
Single person. Page 2 is the FIR, Lordship. If you Lordship kindly see the page 2.
Vehicle.
Should have the brief at first, na? On the calculation brief to the.
কেন ওটা কি প্রমাণ নয়? আমি আওয়াজ দিয়ে দিই না পরে আপনি শোনাবো আওয়াজ ছড়ে আমি হুসেনের খাতে সত্যেন্দ্র আন্তি উল্লেখ করবে
Last date is on 18th September 2023 for cross-examination of PW8, whose warrant was issued on 1st February 2023.
Yes, why you have taken time for cross-examining the witness?
I'm not taking time.
You have not taken time.
I'm not taking time.
What is this page 3 list of dates?
We have seen. Now,
Last-
last page of
last.
the brief.
This is your brief. 18-9 for cross-examination. For cross-examination means chief has been complete over.
PW8.
Cross-examination of PW8, that is it's your part.
And 1/2/23 warrant of arrest against the
Yes.
investigation officer PW8.
Ultimately, he was examined.
He was examined and now your for cross-examination date has been fixed.
18 September. What happened, Mr. Ganguly, on 18 September?
18th September. This is August. September.
Oh.
Not appeared in investigation
We are-
officer, not appeared.
6th September.
We are in advance. যে ও সাক্ষী দিচ্ছে না বলে কোথায় PW?
Many dates she didn't appear.
Summons up from PWA.
Mr. Ganguly, kindly come to the last page of the brief, penultimate page. On 30th of June 2023,
30th June.
আচ্ছা, আগের দিনে
Oh,
দেখুন
30.
issue summons on PWA.
no, what is
No,
this?
sir, not present.
This was
Issue,
30th.
fresh summons of PWA, Devbrata Kundu,
সেখানেও আবার issue summons on
18/9.
No,
Same thing, Lordship.
warrant of arrest was issued.
Warrant was issued. It was issued on 1st February 2023.
No, is
If
that,
they have annexed the order.
did you find that record in your case diary? That factum of issuance of warrant of arrest?
That's after subsequent to the charge sheet, because they only contains the charge sheet.
সেই আগের দিনও আছে।
যে warrant issue হয়েছে সেটা করতে করেছে।
তারপরে next date has been fixed on 18 তো বলছে for cross examination.
First
সেগুলো ও
February
বলছে
2020
নিশ্চয়ই এসে ডিপোজ করে গেছে। এই
Accused on
No, we think that chief is not complete, because kindly come to 24th page, last page, that page of the petition.
First is order.
30th of June, last order was issue fresh
30th June issue fresh summons, 18
for production of the,
Lordship, but she says and
She
further
has said,
cross examination also.
but that is 30th of
Lordship,
June. Now the
the order,
next-
so
First is order তারা
so
No, no,
further
this-
cross examination means.
18th of September has not come as
No,
yet.
no, Lordship.
He
So,
may have,
so he did not turn up. It's your mistake. It's not for further cross examination, for examination.
examination.
It's for examination.
Examination.
I have seen the further cross examination, so chief has been over. It's your mistake.
Ashok,
আসছে না witness, prosecution witness আসছে।
the present application such and such, your নাম কি বললো ভদ্রমহিলা? Miss Pal, learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated. He is languishing in custody. He is languishing in custody for more than 6 years. Stop. Out of 13 witnesses, only 7 had been examined. And as such, there is no possibility towards conclusion of the trial in the near future. Stop. She further submits that the investigating officer himself did not appear before the learned court below for examination on 3 dates. Investigating officer, comma, who is PW number 8. Stop. The delay, it is thus explicit that the delay which had occurred is directly attributable to the state.
Lordship, page 51, the warrant of IO is there. It appears it appears.
ওটা কি বললে? ওই প্যারাটা পড়ো, she further submits. As the investigating officer was not appearing for examination, a bailable warrant of arrest was issued, as would be explicit from the order of the learned court below, order passed by the learned court below on 24th of February 2023. You are?
I want to state your orders.
Stop. The said officer has still not appeared for examination, and the next date is fixed on 18th of September 2023. From the said sequence, it is explicit that the delay which has occurred is totally attributable to the state. She further submits that deprivation of personal liberty without ensuring speedy trial would not be in consonance with the right guaranteed by Article 21 of the Constitution of India. And in the said conspectus, further detention of the petitioner is not warranted. Mr. Ganguly, learned advocate appearing for the state, however, submits that contraband substance above commercial quantity has been recovered from the possession of the petitioner, and as such the statutory restrictions are clearly attracted. Stop. Clearly attracted. Stop. If heard the learned advocates and considered the materials in the case diary. Stop. From the sequence of facts, it appears that the petitioner cannot be held responsible for the delay which has occurred. Stop. He is languishing in custody for more than 6 years. And in view of the conduct of the prosecution, it appears that there is no possibility towards conclusion of the trial in the near future. Stop. In several cases, ওই প্যারাগ্রাফটা আছে না হুসেনারা বলেছো সেটা হুসেনারা and Saji, it was inter alia observed such and such. Stop. Stop. Reliance has also been placed upon the judgment delivered by the Honorable Supreme Court in the case of Satyendra Antil. Stop. Applying such proposition of law to the facts of the case, we are of the opinion that further detention of the petitioner, who is in custody for more than 6 years, is not warranted. Allowed 10,000 to sure 10,000 to sureties, one local, with a further condition that the petitioner.
Petitioner is reside out of state, so it should not leave the jurisdiction.
Achha. With a further condition that the petitioner shall not leave the jurisdiction of Kangpokpi police station.
Khoribari police station.
But he's residing.
Lordship, he is
Oh,
Manipur. So he should not leave this jurisdiction, Lordship. The narcotics hub of India.
With a further condition that the petitioner shall. ওটা 20,000 করে দাও 20,000 each, with a further condition that the petitioner shall reside within the jurisdiction of Khoribari police station until further orders, and shall court is within that. No.
No. Court is Shiliguri.
Until further 7 except for attending the learned court below on all the dates as fixed for.
And for that, he has to intimate the police station that I am going to the court and reporting, because his movement has to be monitored.
Khoribari police station until further orders. It is further directed that he will attend the learned court below, that he will it is further attend the court below on all the dates fixed for hearing. Stop. Before leaving the jurisdiction for attending the court as directed, he shall take necessary permission from the officer in charge of Khoribari police station. Stop. Not to tamper and everything. In case of violation, cancel. Petition dismissed.
I can dismiss. She said.
Who is your senior? Who is your senior?
Abhilash Chetri.
Avinash
Chetri.
Chetri. Ask him to give you back the material instruction. Yes, next. Thank you, Mr. Ganguly. You had been fair. Yes. Yes.
এটা অনেকবার এই commercial quantity ওটা dismiss করে default করে
No one appears on behalf of the petitioner and no accommodation has been sought for. Though Mr. Sarkar, learned advocate appearing for the state is present, in view thereof, the application being such and such is dismissed for default. Yes. Same. Who is in 13? ওই same order Mr. Nag করে দেবে। কিছু হবে না, half. 14, who is there? You are there? Hillal Poddar has not come. Or he does not want to enter. Dismiss for default. Yes. Same,
I have
same
to
order. Same order. ওইটা লিখো, অভিজিৎ, no one appears on behalf of the petitioner and no accommodation has been sought. ওই তো, Mr. Nag, which matter did you appear? 13, 14?
13, 14 and 15.
লিখে নিয়েছো? And who appeared in 12?
12, my lord, Mr.
Mr. ঠিক আছে। Now, yes, 16. Yes, Mousumi Das. এটাও কি তাই?
এগুলো মৌসুমী দাসটাও হিল্লোল পোদ্দার appear করে।
ও, সেম অর্ডার করে দাও ওই মিস্টার গাঙ্গুলি নাম।
17, I for the state, my lord.
Who is for the petition? Oh. Sure. NDPS.
Lordship. Small point, Lordship. May it please your Lordship. Seizure was done on 29th March 2023. The articles were produced before magistrate for inventory certificate on 25/4/2023, 27 days. Now, Lordship, this delay,
How many? 25 days.
27 days, Lordship.
Hmm.
Now, I place reliance upon. First,
Then when it was sent for FSL? After.
after. It is not that case. Lordship, I.
52A.
52A.
Key 52A, which one?
2. Where any narcotic drugs or psychotropic substance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs or psychotropic substance containing such details relating to their description, quality, quantity, such and such, drugs as, or the packing in which they are packed, country of origin and other particulars as.
Just a moment, my sister.
Lordship. And make an application to the magistrate for the purpose of certificate such and such. Number 3, as soon as may be. Now, Lordship,
Make an application for.
before the magistrate as soon as may be. In 3, there is as soon as may be. Now,
But the magistrate will allow.
there's the second part. 3.
No, as soon as maybe, where do you find?
Lordship,
In 2, there is no as soon as maybe.
no. I'm coming to
No,
that.
3 is for the magistrate.
3 is for the magistrate. It shall be sent to the magistrate. Now, previously, as per 1 of 88, the standing order, it was 72 hours. But I humbly submit, Lordship, after the judgment of Union India versus Mohanlal, the standing order is not in effect at the present moment. May I place reliance on the judgment and place
In Mohanlal, 188 was considered guideline.
Lordship, kindly, Lordship, kindly sees paragraph 15, first 15, Lordship. Paragraph 15. Page 409.
How long you are in custody?
Lordship, I'm in custody for,
এটা দেখতে গিয়ে ওটা ভুলে গেছে।
Lordship, 160 days.
Oh.
No, I'm not regarding the detention. I'm the illegality which has been caused. Lordship, para 15, if I read, Lordship. It is manifest from section 52A2C supra that after seizure, the contraband, the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under 53, who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for the purpose of certificate of correctness of the inventory, B, certifying photographs of such drugs taken, the magistrate as true, and C, draw representative samples in presence of the magistrate. Now, para 16. Subsection 3 of section 52 requires the magistrate shall as soon as may be allow the application such and such. Now, para 17, the question of drawing samples at the time of seizure, which more often than not take place in the absence of magistrate, does not in above scheme of thing arise. This is so especially when, according to section 52A4 of the Act, samples drawn and certificate of the magistrate in compliance with subsection 2 and 3, Lordship. 2 and 3, 2 is production before magistrate, and 3 is magistrate shall do both. Of section 52A above constitute primary evidence for purpose of trial. Now, Lordship, kindly sees para 18, which says that standing order.
Next line.
Lordship.
That is perhaps
why none of the state claims to be taking samples at the time of seizure. Here also samples were not taken at the time of seizure. It was sent to the magistrate only. Para 18, that's that the dilution of 1 of 88 is there. Standing order. Be it as it may, a conflict between the statutory provision governing taking of samples and the standing order issued by the central government is evident when the two are placed in juxtaposition. There is no gainsaid that such a conflict shall have to be resolved in favor of the statute on first principles of interpretation, but the continuation of the statutory notification in its present form is bound to create confusion in the minds of the authorities concerned instead of helping them in discharging their duties. The central government would therefore do well to re-examine the matter and take necessary suitable examination. Now, para 19 is very important for us. Mr. Sinha, learned amicus curiae, arguing that if an amendment of the Act stipulating that the samples be taken at the time of seizure is not possible, the least that ought to be done is to make it obligatory for the officer conducting the seizure to apply to the magistrate for drawing of samples and certification, etc., without any loss of time. Now, this has been elaborately discussed. Well, the officer conducting the seizure is also obliged to report the act of seizure and making of the application to the superior officer in writing, so that there is a certain amount of accountability in the entire exercise, which as at present gets neglected for a variety of reasons. This was a submission. Now, opinion. There is, in our opinion, no manner of doubt that the seizure of the contraband must be followed by an application for drawing of samples and certification as contemplated under Act. There is equally no doubt that the process of making any such application and resultant sampling and certification cannot be left to the whims of the officer.
That is the view of the amicus. What did the court say?
There is, in our opinion, that is court is saying.
Where?
After the amicus reasons end, there is, in our opinion, no manner of doubt,
Cannot be left to the whims of the authority.
like whims of the concerned officer. The scheme of the act in general and section 52A in particular does not brook any delay in the manner of making an application or the drawing of samples and certification, does not give any delay, which we see no room in prescribing or regarding a team framed into the provision. We are of a view that applications so and so forth.
Problem.
Now, Lordship, the view that
Your argument is there was a 25 days.
27 days delay without any explanation. Now, during this interregnum period,
Explanation to whom?
To
They
the-
file
no.
the application.
Lordship, the officer after seizure has to make it give an application before the concerned officer superior.
Observation of the court.
And Lordship, these articles were kept at the police station Malkhana, not at the central Malkhana or under certification of the magistrate. Prior to that, this chance of manipulation and the thing is there. Lordship, I am relying upon a latest judgment of Honorable Apex Court.
Magistrates and the agencies that are dealing with the manufacturer.
The court has hoped that High Court is there. Lordship, this is the latest judgment of Simranjit Singh versus State of Punjab.
It has been placed before us.
Acha, Lordship, in
That conviction was set out.
set aside as because that 52A2, which I emphasize upon the seizure of contraband, paragraphs, Lordship, 17 and 9, para 9, Lordship.
17 is.
No, Lordship, para
quotation of
8 is 15 to 17, the Mohanlal has been discussed, and
Yes.
para 9. Hence, the act of Petula 2 of drawing samples from all packets at the time of seizure is not in conformity with the law laid down by this court in the case of Mohanlal. This creates a serious doubt about the prosecution case, and the substance recovered was a contraband. As because, why?
Was convicted by
Lordship, Lordship, in our case,
No, paragraph 17 of Mohanlal can read the question of drawing samples at the time of seizure, which more often than not takes place in the absence of magistrate. Does not in the above scheme of things.
Lordship, this is
does not
52,
in
3, then it is 3, para 16.
Sampling টা তো হবে
Lordship,
magistrate-এর সামনে। এটা certify করবে।
Lordship,
Sampling has to be before the magistrate.
magistrate. Now the thing, what I am
If the officer does sampling at the time of seizure,
seizure,
that is wrong.
that is wrong.
Uh,
Now, prior to this amendment,
Your only ground is
no,
no explanation.
1 minute. Prior to the this insertion of section 52A, there was a standing order of one of 88 and 89, which says within the sample, after drawing the sample, within 72 hours, that should be sent to the magistrate. Why, Lordship? As because till the contraband mother packet is sent to the magistrate, till it is retained by the police officers.
We understand.
So manipulation, that change of contraband, everything can be possible. And
But-
that was the intention of legislature.
Mohanlal considered circular 188.
188, not 188. It has cartel 188 in para 18, Lordship,
That has been superseded statutory
by
provision.
statutory provision.
188
52A,
are override 50.
over a 52A.
But subsequent thereto, there had been further guidelines.
Yes, Lord, it has strengthened Mohanlal. It has strengthened Mohanlal.
Where is that? Show us that what is the subsisting guideline that it has to be sent by 24 hours or 72 hours. Where is that?
No.
There is no mention.
No,
of
time limit is not there. I am
52A
submitting is not
also,
there.
52 also does.
Time
not
limit
say
as soon as may be. Now why I am saying so? For 20. So my only condition is that
সেটা ডিফারেন্স প্রসিজারে আছে ওই স্যাম্পলটাই আমি পাঠাচ্ছি 4টে প্যাকেট এক্সিবিট মার্ক করে দিচ্ছে A B C D এবার ওইটা ম্যাজিস্ট্রেটের সামনে এসে বের করে দিচ্ছে
So my only condition is that the intention of the legislature by giving that standing order 72, the time frame was as soon as maybe it should be reach the magistrate, because within that period the contraband may be changed or anything tampering, because it was not kept in under certification of by the magistrate. Here for 27 days those contrabands were kept at the police station by the officer. So anything can be possible with the mother packet, lordship.
How do you overcome the regard of the issue that this is a factual issue which has to be considered in the course of trial?
Lordship,
Judgment of Supreme Court is setting aside a conviction after the person was found guilty.
Why we see no?
found guilty, but on the point that those 52A was not considered, lordship.
And the magistrate appointed it. Without any delay, the certification is application.
52A was not considered, and that is the reason when the conviction goes, so the lordship knows Taylor versus Taylor, the what has been stated by the statute has to be strictly complied. Now 52A says as soon as may be. Now if there is a delay of 27 days, let the state explain the delay of 27 days.
Decent করে গেছে এবং আমার মতে she rightly decided because the issue prior that he was decided by a special নাম
Nariman.
কথা বললেন but he did not take note of the issue which has been cited. The individual was actually
Lordship, now let the state give explanation for 70 that delay.
My lord, this is the status report submitted by the IO before the lower court. This is
Yes, Mr.
My lord, there is no explanation. It is fact. My lord. There is no explanation. This is the status report.
And the contraband was written.
300 gram, my lord, 300 gram of brown sugar, and investigation is still going on, my lord.
Charge sheet not filed.
No, my lord. Charge sheet not filed.
Which paragraph, Mr. Nag?
My lord, last three.
Goes to all season. And we take there. No, this fact is right that the seizure was on
Yes, my lord.
29th March.
Yes, my Caesar list on page 18, my
18.
page 18.
And it was application before the magistrate was when?
My lord, it
25th.
was certified on 25th
April 20.
April 20. It is fact.
On this interview,
explanation.
29th March 2023 পাঠিয়ে চলছে।
27.
Mr. Nag,
Yes, ma'am.
after the seizure, where was the contraband kept?
My lord,
It is not sent to the as an alamat to the storeroom.
yes, ma'am.
It is must be kept in the police
station.
But there is no reflection in the CD where it, those articles kept. My lord.
You are a family man.
Yes, lordship. And I've given a 48-page judgment.
Don't
on
give
this.
judgment. You tell us, are you a family man?
Yes,
Residing
lordship.
with family.
Yes, lordship.
কোথায়?
Lordship. Lordship, I'm a resident of Shitalkuchi, Kuchbihar, Lordship. Lordship, this is a lady, Dipti Bormon,
Dipti Barman is a lady.
Lady.
Oh,
daughter of, and a resident of Kuchbihar only.
where have you stated?
Lordship, in the post-stated lordship, in the matter of Dipti Bormon, daughter of,
You are a married person.
daughter of, no, unmarried person,
You are an unmarried person.
daughter of. I am my parents, I look after them.
এই করতে করতে শেষ হয়ে গেল। DPS আর arrest করে রাখতে হবে। Now, after you made the application on 26th April to the magistrate,
Yes, my lord.
where is the order of the magistrate thereafter?
My lord, page
That's I am certifying.
page 100, my lord. Sir.
Foundation of the case, manipulation will not be a free at free হবে না তো at the time of manipulation of data to unexplained time of visit now how is it possible certification was on 25th April
Yes.
but you sent it to the magistrate on 26th April.
No, my lord. No.
It
It was sent to RFSL on 26. my lord.
Hmm?
After certification, it
Duly
was
forwarded to learned ACJM code, vitae on 26 to
Yes,
the
sir.
office of the, oh,
it was sent there after my lord. On 26, it was sent. my lord.
সেটা inspected. Oh, see, my before the, before the 18th April, you send it on 11th.
April 18.
ফেরুচা, seized হয়েছে 23 So where is your application for certification?
Application, my lord.
একটু দাও তো, please tag those pages. This one.
That is lordship, without satisfactory explanation, bail was granted.
Coordinate bench order.
She was a housewife.
Without satisfactory explanation, bail was granted.
দেখ
ওই আরেকটা দিলাম যে দুটো আছে। Para 4, similar point. 5, 6. Without any satisfactory explanation. why it was retained for so many days in the custody.
My lord, this is the order of the
না application টা কোন
application.
which on 18th of April 2023 the application was submitted.
Is
49 days the delay. That the 90 days for the samples were sent. The person is going answer for the interview.
and thereafter on 24th April on order was passed.
Lordship, since the date when the articles are produced before magistrate.
Oh, 18.
And it was sent for FSL when?
It was sent for FSL on 26th April 2020, page 75, my lord.
We cannot delay. It's getting for the sampling for the delay. Sampling date.
18-23 থেকে 18 কিন্তু আলটিমেট সার্টিফিকেটটা পেয়েছে। Where is this?
Next page, next flap is the order, my lord.
25 certification at my chamber.
Mr. Ganguly, Learned Council appears on behalf of the petition. And petitioner and subjects. That there has been.
Your petitioner is a married lady. Paragraph 2 you have said.
And you.
Lordship, this was drafted by one of the junior, is in council.
Paragraph 2, you are so overwhelmed with your submissions that you did not take note of the awareness.
I apologize, Lordship.
And you did it in CV of the contraband substance. And
Housewife by your profession. Maybe
sending the
divorce,
same
Lordship, because
for
daughter of.
sampling by the first class judicial magistrate. Full stop.
Never write housewife now. It is now homemaker.
He submits that without undue delay and as soon as it was possible, the same should have been sent for certification. Furthermore, he submits that such delay has not been explained by the state authorities. Next. Mr. Nath from Learned Council appearing on behalf of the state submits that the offense committed by the petitioner is grave in nature and as such, the rigors of section 37 of the Narcotic Drugs and Psychotropic Substances Act 1985, within that of NDPS Act. Are clearly applicable. Therefore, the prayer for the should be rejected. Next. considering the rival solutions of the parties
Join.
and
শুনুন
it was seized on March 23. On March 23, 2023. And an application was March 23.
দেখে নিচ্ছি আমি,
March 23.
দেখে নিচ্ছি।
And an application was made for certification on April 8, March 29,
It's 29th.
on March 23.
It is 29th March.
29th March 2023.
March 20. And an application was made before the learned magistrate for certification on April 18, 2023. Furthermore, there is no explanation as to why the said no explanation as to why there was delay in making of such application by the officer in charge, Matigara Police Station. Full stop.
ভিতরে কোনো explanation নেই। ঠিক আছে, বলে দিন। সার্টিফিকেশনের অর্ডারটা রয়েছে 25/4। এই তিনটে পাঠিয়েছে, অ্যাকচুয়াল সার্টিফিকেশন হচ্ছে 24টা, তার মানে আরো 6 দিন লাগবে।
The learned judicial magistrate passed an order of certification April 25, 2023. 25th of April. Yes. Therefore, this court is of the view that the observations made in the judgment of the apex in Union of India versus Hon'ble and another reported in 2016 within bracket CHCC 279 regarding the sampling and certification ought to be made without undue delay has not been complied with. Full stop. It's private citizen. Therefore, therefore it directs the petitioner to be released on bail.
So, manipulation is যখন প্লেস করবে তুমি অ্যাড করে দেবে।
কতদিন কত
আরেকটা কি possibility of
Now, this court also finds that the petitioner is a homemaker and the possibility of her being from the jurisdiction of the learned trial court is negative.
It's no question. কত দিয়েছে? ওই 10,000 20,000
upon the condition 20,000, two sureties, one local. I think the charge sheet of will cooperate with the investigating officer and shall uh, report,
এটা বলে দিই, was placed before.
and shall report once a week before the investigating officer from Matigara. তাতে কিছু হবে না, কারণ এটি very strict.
She's a lady.
Maybe, but
Charge sheet not filed yet.
Lordship,
বলে দাও, ওই decision-টা নিতে হবে।
সেটা বলে দিয়েছি কিন্তু
Lordship, there is a woman police station in every police station. So if it is directed to meet the woman officer in charge of woman police station,
Where is it? Where is the case register?
Matigara police station. Lordship.
Matigara.
That is not a women police station.
No, in every police station, there is a women's cell, women's police station also.
there is in Matigara police station, there is.
Shiliguri women police station.
No, no.
Police station.
Matigara is under Shiliguri. Isn't
বলো না,
in Shiliguri. Lordship.
inspector-কে meet করতে হবে।
Okay, inspector, Matigara police station.
Matigara inspector in charge.
Officer, OC, OC.
Once a week,
Once a
till
week.
completion of the investigation.
সেটা বলে দিয়েছি once a week, সেটা বলে দিয়েছি।
Investigation শেষ হওয়া
Once a week till completion of the investigation.
না হলে until further notice.
না, 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 till completion of the investigation. আর আচ্ছা, আচ্ছা, আরেকটা বলবো, tampers বলে দিই।
হ্যাঁ, ওগুলো বেরো আমি তো
You will not tamper with the evidence or.
ওই জায়গাটা রিলাই করেছে তো বলে দিয়েছে।
আর ওইখানে যেখানে Learned Council for the petitioner আছে না, ওখানে একটা act করে দিয়েছে। He also relies on an order dated August 24, 2020, passed by a coordinate bench in CRN within bracket NDPS bracket 603 of 2020 in support of his contraction.
Deeply obvious, deeply obvious, Lordship, deeply obvious.
Let's move on.
Yes, next.
এখন তো investigation চলছে তো,
এখন তো investigation
এখন তো
charge নেই
charge sheet file হয়নি।
Charge sheet not filed.
Your Lordship, I pray for time.
Who is for the state?
I'm for the state.
The other, an adjournment has been prayed for on behalf of the petitioner, though Mr. Sarkar, learned advocate appearing for the state is present. Please the matter before the next available sir. Or possibility নেই পাঠিয়ে দেওয়া। আর motion মনে করলে আমি বলবো, তোমার কাছে তো আমার কাছে তো আসবে ওটা। Yes, দেখো 21 কি আগে 19 কি আছে তো আগে কি ছিল? What NDPS?
No, my lord, 302, my lord.
No one appears on behalf of the petitioner and no accommodation has been sought for. Though Mr. Mishro, learned advocate appearing for the state is present. So, in view thereof, the application being is dismissed for default. Yes,
Lordship is praying for time.
we an adjournment, owner নাম দিয়ে দিও state. Next circuit, yes.
Your Lordship, praying for next circuit.
Who is for this state? Give your appearances, next circuit.
22, I'm paying for next circuit.
Same order.
Lordship, I'm taking for accommodation. Matter relates to NDPS may be fixed on the next circuit, subject to your Lordship's convenience.
ওই সেম অর্ডার করে দেবে। Yes,
এটা তো আমি বলতে পারবো না।
Lordship, I beg to appear for the petitioner.
yes.
Lordship.
Yes,
Lordship, this is a case under an offense has been registered under section 17C of the NDPS Act. And the contraband in question was that of 270 grams of brown sugar. On the date of 7th of November 2020, 3 people were intercepted at a place called Pashakamur under the jurisdiction of Joygaon police station. Thereafter, it was alleged that they were carrying 270 grams of brown sugar, joint possession, and the brown sugar was contained in a plastic pouch wrapped in a paper. That was the allegation. Thereafter, what has happened that on the date of 17th of May 2021, the charge sheet was filed. The charge sheet was filed, but without CFSL report.
you did not press the application on 2nd August.
Yes, Lordship. Upon instruction from the learned advocate, from whose brief it contained, he instructed us to not press the application, and accordingly it was not pressed.
So what had
Previously,
been,
also before that, Lordship, if I may, it was there was a couple of bail applications which were preferred before the Honorable Court, and previously it was preferred on 11/1/22 and 27/2/2023.
so what is the change in circumstances?
Lordship, the change in circumstances is that kindly come to page number 13 of the bail application, the first order of rejection. Page number 13, on the 2nd paragraph, Lordship.
How long you are in custody?
I am in custody, Lordship, for 1,000 days. For more than 1,000 days, and near about 3 years. And
How
in
many
page number
witnesses?
13, Lordship, sorry.
How many witnesses?
Lordship, there are a total of 8 witnesses, and as of now, the trial has not commenced. None of the witnesses has been examined.
Charges framed?
Charges has not been framed, Lordship. Lordship, if I may, on page number 13 of the first order of rejection, there was a categorical direction that was made that we direct the state to take all necessary steps so that the FSL report is available within 4 weeks from the date and is immediately placed before the learned trial court. This is, Lordship, on 11th of January 2022. After that, within 4 weeks, it was not filed. It was not filed, which constitutes a material non-compliance of the order of the Honorable Court.
So why didn't you say that when you could have said that on 27th?
Lordship, I agree. I humbly accept that. But the fact is that we were not bestowed with this case on the second order when the second bail period was rejected.
So how can you now plead for an for something which you did not argue there?
Lordship, I humbly apologize for that. But Lordship, I am on the fact.
So FSL report, when was it available? Ultimately, FSL has come.
Lordship, till today, as per my instruction, till today, the FSL report has not been.
It has come.
It has come now, but Lordship, if I may, on 30.
Wait.
All right, Lordship.
Lordship, charge sheet was submitted on 17/5/2021 with a prayer that after collection of the FSL, supplementary charge sheet will be submitted. Now, FSL dated 26/7/2021.
Lordship, if I may.
Wait.
All right, Lordship.
Yes, now.
Now the FSL is here.
Yes, now supplementary charge sheet filed.
Lordship.
So he will be again praying on long detention. Charges have not yet been framed. Since 2020, the case was registered. Only sole accused?
Accused.
3 accused, Lordship.
3 accused.
3 accused. Others are absconding.
Joint position, Lordship. All are in custody.
No, all are in custody.
All are in custody. এটা দিতেই
Rajkumar,
তোমাকে অন্য
Jayarul and Manoj Burman.
What was the quantum collected from each?
Quantum Lordship, 270 grams of.
That was
sugar.
total.
Total.
They were individually found to be in possession of.
Lordship, it was a joint and consensus possession. Serial list page 4. I'm placing the serial list Lordship, here. From the joint possession.
এই তুমি ইংরেজি ল্যাঙ্গুয়েজে মানুষটা ফল ধরে তুমি বের করতে পারবে না। এগুলো হচ্ছে এসআই লিখছে, ওরকম মাথায় লিখে গেছে। তুমি যেভাবে খুঁটিয়ে পড়বে, ওই স্কুটিটা তো ও এক্সপেক্ট করে না। ঠিক আছে, নিও না যে আমি কোনভাবে সত্যতা ইউজ করলে কি ইন্টেনশন। So what is what is the change in
Lordship,
circumstance?
the CFSL report that is available today, this particular matter was lastly heard on 30th of August. On that day, the CFSL report was not there. I am of the belief that it has been made in the last couple of days.
So
however, Lordship,
how does that help you?
Lordship, I am on the ground of long detention, Lordship, and in that regard, I have a judgment of coordinate bench. Lordship, this judgment was passed on 14th of August 2023 by a coordinate bench of this honorable court, wherein the accused petitioner in that particular case was in custody for 2 years and 20 days. And in that case, the accused petitioner was granted bail. This is CRM NDPS number 414 of 2023. Other than that, Your Lordship, I have 2 other judgments of on the ground of CFSL report, wherein it was filed long after the filing of the incomplete charge sheet. This is CRM NDPS number 95 of 2023.
So who prevented you from arguing on 27th February that the FSL direction has not been complied with?
Lordship, I humbly apologize, but then I was not.
So that cannot be a ground.
I accept, Lordship. But the
So
fact is
your
that I am in
belated
custody.
submission of FSL goes.
Lordship, I am in custody for 1,000 days without any material progress of trial. And this runs directly in contravention to the spirit that emanates from state Husainara Khatun versus State of Bihar.
Unless you expedite things, you cannot prevent anybody from getting bail. So the problem, first intervention was Tufan Singh, co-accused, though Justice Indira Banerjee deferred with decision, and she relied upon a prior special bench judgment. So co-accused statement, give bail. 52A, you are not saying why explanation not given. How do you expect from a sub-inspector what explanation? Can he write English? And if you minutely go through the recording of the inquiry officer, which we need not do at this stage because it's a question of trial, but now judgments are being placed before us. We are handicapped. Now, if we give one to this person, the remaining 2 persons will also get bail. So what your police will do? They will close the file and go to sleep. And society is destroyed. All the youth of our society will be destroyed. Because it is for you. You being the prosecutor, you are not conscious about the steps you are required to take. There is no invigilation. You can make a guideline that if the SI does not act within this time, a disciplinary proceeding will be initiated against him. Unless you give a threat, nobody will listen to you. And our society will be spoilt.
So workshops are held and we also take good
Workshop.
but
Unless you give threat to the person that we will be suspending you, he will not move. I mean, government service.
police only is afraid of the court and
No, it is not a question of, it should be an attitude. It is not a question of threat. He is in police, he doesn't know. The lacuna is being created by the police so that they can come and take the bail and go off. Their problem will go because they don't have to conduct investigation. Oh, bail granted, let us close the file. And you tell us how we differ from this judgment. Here it is being given 2 years, 2 months, give bail. You do not distinguish Ravi Prakash also. We do not get a formidable argument from the state that why Ravi Prakash should not be followed. In Ravi Prakash, we find 3.5 years was the delay. So this is 2 years, let us not give. But how you know, in Ravi Prakash, there one witness was examined. That also it was given. That was given in consideration. So on similar fact situation, we can give. But we are getting orders where coordinate bench has granted. That is due to the lack of submission and lack of appropriate steps to be taken by the courts. You can prevent none. Today we will give bail to him. Remaining 2 persons will come in the next circuit and give. Unfortunately, unless the administrative authorities wake up, you can never prevent the crime of any. Pages after pages, argument would be advanced. 52A, you are not followed. 50 notice, you have not given. The officer went with the gum and envelope to the side so that he can write down that 50 notice. Judiciary will be helpless. You should be serious. The investigating officer should take up the issue. They don't have a... Can you distinguish, Mr. Ganguly? Can you?
He has not given a copy of this then.
I do not have enough copies. I have,
Argue
this is for,
if you can,
I'm giving my copies.
you have to make arguments.
Tomorrow,
Lordship, I have been in detention for far too long, Lordship.
at least
Lordship, I have been in detention for a very long time, Lordship.
Ashif, Friday 10:30 or I need half an hour time.
Lordship, I have been in detention for a very long time, Lordship. And Lordship, if I may be allowed to make one more submission, Lordship.
Yes. All right, come at 2 p.m.
Lordship,
2 p.m. I'll get a copy.
2 p.m. we have a fixed matter.
Wait.
You call that officer that if the 3 persons are left, where we will see that we will observe that proceedings will be drawn against the officer.
It
মানে কি রে?
বসেনি এখন সেশন মানে বসেনি
আমার কিন্তু দুটোতেই ফিক্সড আছে।
হ্যাঁ বসেনি এখন বসবে তো আপনার ভিজিবল হবে তার
মানে আমার
সব
কিছু
অন
করার
করে
নাই।
রেখেছেন তো এটা শুধু অফ করে নেবেন টিপে দেবেন মিউট হয়ে যাবে আপনার খোলা থাকে কারণ আপনি কথা বললে তো
This matter, what is the name of the lady who appeared?
My lord, my lord,
No,
I am
no.
for the petitioner, my lord.
Just now we passed the order. That is Kalipodo Das must be her senior. The lady appeared, na junior member who appeared.
দীপিকা পাল আছে, এখানে লেখা আছে list-এ।
লিখে রাখো তো।
List-এ আছে দাঁড়ানো। দীপিকা পাল, হ্যাঁ, দীপিকা পাল।
না
তুমি
ওটা
list-টা দেখে নাও,
ওটা আমি দেখবো তারপর।
ছাড়ানো আছে।
দিন একটুখানি। লিস্টে যদি লেখা থাকে তাহলে এত অসুবিধা।
list-এ লেখা।
এটা আমার চেম্বারে পাঠিয়ে দিই।
My lord, item number 65 and 66 as was mentioned for your lordships in the morning. My lord, I have already served notice. My lord, that school matter.
2065 কোন 2 PM? তাহলে 2 PM who is in the 2 PM matter? Oh,
My lord, I am for the petitioner.
just আমার লিস্টটা নিয়ে চলে যাবে, আমার লিস্টটা দাও। Please, Mr. Rahman, wait, we have a 2 PM fixed matter.
Lordship. 20.
না এইটা কেন দিচ্ছ?
24.
ওটা তো হয়ে গেল, প্রবলেম
I am for the state of lordship.
এটা কত নম্বর আইটেম?
এখানে 11 নম্বরটা হলো দীপিকা।
11 নম্বরটা অ্যালাউ করেছি ও তাহলে তাহলে দেখি এটা কি 9 নম্বরের অর্ডার তো পাঠিয়ে দাও তাহলে গিয়ে দেখি 11টা কে নিয়েছে হ্যাঁ 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 একদম। ঠিক আছে তাহলে আই মে হ্যাভ মিসড পাঠিয়ে দাও আমার চেম্বারে ডাকো ডাকো 2 PM হ্যাঁ বলো তুমি দেখেছো ডিভিশন? মিক্সার ফিট করে দেবে আমার কাছে আছে তুমি দেখো এইটা তুমি করতে পারো সেকেন্ড ফাইলটা করতে পারবে judgmental দেখতে চাইলে Mr. Banerjee, have you considered that Sudeep Sen judgment?
Yes, my lord, I have considered the Sudeep Sen judgment, my lord. My lord, in the Sudeep Sen judgment, my lord, the Honorable Court have directed 4 points, my lord, regarding consideration of the second application, my lord. My lord, in the second application consideration, point number 3, my lord, which has been C, there has been categorically mentioned in the case where the first application, if there is a subsequent changes, then second application is maintainable.
Yes, move the second on the ground that the court on earlier occasion, the faction is due to subsequent events or any subsequent change.
Yes, my lord. And my lord, there is a specifically mentioned that nothing should be treated as a second application where something is there but not considered at the time of first application.
Yes.
But my lord, in this case, my lord, what is the difference between the order? In this case, what has been considered, that is not on the case record, my lord.
Just to
What has been considered, that is not in the record, my lord. On the basis of erroneous submission, my lord, my petition has been rejected where others granted anticipatory bail. And my lord, my humble submission is that, my lord, in this petition, which has been considered, that is not on the case record. It is an erroneous submission from the prosecution side, my lord.
Oh, that is the observation of a coordinate bench.
Yes,
If
my lord.
that observation is wrong, what is your remedy? Tell us.
My lord, kindly.
Coordinate bench has said that you were the person who kicked, for which
Yes,
the
my lord.
miscarriage occurred. This is a fact. This is the
Yes.
record.
This is
Now
the record,
we
my
find
lord.
from the records that line is missing in the 164 statement.
Yeah,
We
even
are
if
with you. We are with you, but
My
we
lord.
cannot, sitting in review, we cannot say that the court made an observation which apparently does not appear to be correct. We cannot say that. We are a coordinate bench.
My lord, but
You bring an authority on that issue, we will consider. Then we cannot take up the matter then. Today you are not ready with the authority. We have explained to you that this is the ground. Please give us any judgment which will show that even if there is an erroneous, if the coordinate bench finds that there was an erroneous recording by the earlier bench, I can accept, this coordinate bench can accept the anticipatory bail. Finished. Because Sudeep Sen is against you. You have to improve upon that case and ascertain. We wouldn't have done this. We could have straight away rejected. But as you are arguing that that specific Because if it is a mistake on the part of the court, it is for the court to rectify.
My lord.
To come with an appropriate judgment and authority on this point.
My lord.
The next circuit.
My lord,
Instances name.
my lord, there's only remedy to go the higher forum against that.
Mr. Banerjee, learned advocate, we are recording that you will come on the next circuit with appropriate material.
My lord.
Banerjee, learned appearing for the petitioner. Prays for an accommodation today to avail necessary instruction. Stop there. The case diary, the case next, list the matter before the next available circuit bench. The case diary as submitted by Mr. Bhattacharya, the case diary is returned to Mr. Bhattacharya, learned advocate appearing for this case.
I'm grateful, your lordships. Next.
Yes. I already served notice upon the other side.
Who is your other side, Mr. Rao? Mr.
Mr.
Chaudhuri?
Mr. Arjun Chaudhary and Mr. Vikramaditya Ghosh.
So where are they?
They were here a few minutes ago.
I think they are, Chaudhary just.
What remains? What order do you want now?
But the first man was appeal to be.
Then you pass over, if they comes, we take it up.
Well,
Yes.
24. Yes.
Yes, Mr. Gandhi.
I'm grateful that lordships have given me an opportunity to go through the judgments and to my little understanding within this short period, I have tried my best. I am placing my case. Lordship, the case of Muhammad Muslim, that is the recent judgment of passed by
Muhammad Muslim.
Justice Ravindra Bhatt and Dipankar Das, latest judgment.
No, that was Ravi Shastri.
Ravi Das.
Ravi Das.
Ravi Prakash.
Prakash. Acha.
Ravi
তারপরে হচ্ছে No, that you are saying the previous judgment.
Previous judgment based on which the Ravi Prakash.
That was by Justice Dotto and by Justice
Bhatt, Lordship.
Bhatt. Yes,
Bhatt.
Ravindra Bhatt.
And our Ravi Prakash is Justice Bindal.
Justice Bindal and Justice
Dipankar Das.
Justice that is by Ravindra Bhatt and I think by Justice Bindal.
Lordship,
But
here
that is
what
on a different altogether.
analogies regarding that
Long detention.
long detention. Lordship, I humbly submit after going through the judgments, what I found that the court would look at the materials in a broad manner and reasonably see whether the accused guilt may be proved or not. If there is a serious violation of any act or any section which would vitiate the trial itself, then obviously, if the bail is rejected, the trial will result in acquittal. In such a situation, court will prima facie see that the long detention will result in nothing and bail will be granted. But in every case, in a case of NDPS, Lordship, I humbly submit that the court has to observe and dilute the rigor of section 37, which says that public prosecutor has to be given an opportunity to oppose, and where he opposes, that means in a case where public prosecutor does not oppose, a lenient view can be taken. Where he opposes, court has to find a twin condition. That is
section 37
itself is there. Now, the accused may not be guilty. The finding,
So where is that consideration by the coordinate bench?
that is I am saying, Lordship.
So then what
That
we
it
are
is
to
only
do?
based on prima facie matter.
So what we are to do, tell us. Your argument we appreciate, that you have to qualitative assessment of the evidence.
37 has to be there.
37, there are two limbs. There is no PP hard, there is no reasonable apprehension that he will not repeat the offense. These are the two
These are the-
riders in section 30.
Like Lordship, if the accused was apprehended by co-accused statement to one scene.
That goes.
So,
No, that will go on that ground itself, not on long detention.
but here it is not there in the judgment. It is not there. Now, Lordship, this is can it be said par incurium? Actually, these judgments were also passed basing upon previous judgments. So, in a chain reaction, it goes.
Charge sheet submitted,
Lordship, yes,
charges
judge
have been
submitted.
framed. There are 8 witnesses.
7 witnesses,
8 witnesses, Lordship.
excluding the.
He was the sole accused.
3 accused,
The accused
Lordship.
person, he is one of them. Now, CFSL have been collected, supplementary charge sheet has been submitted.
Is there any antecedent
No criminal antecedents, Lordship.
that you have checked up
Yes, in the case that he is not there.
in this case?
Yes, in this case.
This Jha,
This
he has no
No,
antecedent.
in
Lordship.
the case,
Will you please keep quiet?
Sorry, I'm sorry.
in the case
You
that
take your seat.
Sorry.
Take your seat.
in the case study, there is no reflection that any previous antecedents are there or not.
বললো 90 days পরে Now, no, charges have not yet been framed.
No, Lordship, supplementary charge sheet was submitted along with the FSL, Lordship, if my role is to.
What is the punishment? How 10 years, na?
It's commercial.
Commercial, it is
it's
10
set to
years.
20 years.
20 years.
Lordship.
So you do not come under 436A also.
No, Lordship, I'm not on that. What I am praying for is that it 270 grams commercial quantity, but nowhere has it been mentioned in any of the documents that whether that is gross amount or net amount. Be it mentioned here that,
Forget about that. That is a question of trial.
yes, Lordship. Lordship, in the what
You have
it was-
no other grounds, 7 except long detention. You
yes,
have
Lordship,
no
that
other
is what I'm praying for. And in that regard,
So
Lordship,
then
if I may,
the Supreme Court Association case is against you. After that, the amendment was made in 436A. Hardcore criminal, it was said 10 years. You can consider leniently in case of who have conspired together. It is a direct evidence. You were there, you have been possessing and you want the bail now.
Lordship, no. In what has happened, there is no criminal antecedents of this particular accused petitioner. Lordship, moreover, what has the seizure of the very contraband is doubtful in nature. Lordship, if I may, Lordship, in the seizure of the contraband is doubtful in nature, Lordship.
The application has been prepared such and such. The learned advocate appearing for the petitioner. submits that the petitioner has been falsely implicated. Stop. He has already suffered incarceration for about 3 years. Stop. Upon completion of investigation, charge sheet has been filed. Stop. Out of total 8 witnesses, filed. Stop. However, charges have not been framed and 8 witnesses charges have not been filed. Stop. There are in total 8 witnesses and none had been examined. In view thereof, there is no possibility towards conclusion of the trial in the near future. Drawing our attention to an order dated 11th of January 2022, passed in the earlier bail application filed by the petitioner. He submits that there was a specific direction upon the state to take all necessary steps so that the FSL report is available within 4 weeks from date and is immediately placed before the learned court so that all further steps can be taken for expeditious commencement and disposal of the trial. Stop. No FSL report admittedly was filed. No FSL report admittedly was filed within the period as specified in the order dated 11th of January 2022. Stop. In view thereof, it is explicit that the delay in the proceedings is attributable to the state. Stop. Is attributable to the state. Stop. He further submits that long incarceration militates with the right guaranteed under Article 21 of the Constitution of India, and the delay needs to be taken as a presumptive proof of prejudice. Stop. In the said conspectus, further detention of the petitioner may not be necessary and he may be enlarged on bail on any stringent condition. Stop. In support of such argument, he has placed reliance upon an order passed by a coordinate bench of this court, pointing out that in a case where the petitioner, in a case where the accused was in custody for only 2 years, 20 days, bail has been granted. Stop. Mr. Ganguly, learned advocate appearing for the state, however, submits that contraband substance above commercial quantity has been recovered from the possession of sole accused, Mr.
3 accused persons.
From 3 accused persons, including the petitioner. Stop. In view thereof, the statutory restrictions are clearly attracted. Stop. From the facts it would stop. There are strong incriminating materials on record on the basis of which the NDPS no finding can be arrived at this stage. That there are reasonable grounds for believing that the petitioner is not guilty of the offense and is not likely to commit such offense while on bail. Stop. However, answering our query, he submits that the petitioner does not have any antecedent. Heard the learned advocates and considered the materials on record. Stop. ওই হুসেনারা ওই আগেরটাই দিয়েছি, হুসেনারা খাতুন, এআর আন্তুলে আর সত্যেন্দ্র আন্তিল, তিনটে জাজমেন্ট আছে, হ্যাঁ, বলে প্যারাগ্রাফটা দেওয়া আছে, in case of long detention. Applying such proposition of law to the facts of this case, and as the coordinate bench of this court has also granted bail to a person who had suffered incarceration for 2 years, 2 months. 20 days. We are of the opinion that the petitioner may be, we are of the opinion that further detention of the petitioner is not necessary, more so when upon completion of investigation, charge sheet has been submitted. Allowed. 30,000. $20,000 2 CODPs, 1 local with a further condition that the petitioner shall not leave the jurisdiction of Joygaon police station, na? Joygaon police station. Your court is outside Joygaon, no?
It's Alipurduar.
No, it's Jalpaiguri.
Jalpaiguri, now it will be
It
Alipurduar.
is within Joygaon.
No, Lordship.
Joygaon police station. তারপর ওই রাইডারটা ওই আগের মামলাটাই দিয়ে দিয়েছি। He shall however attend the court on all dates upon intimating the officer in charge of Joygaon police station. Permission, obtaining permission. After ওইটা তুমি পাঠিয়ে দিও, obtaining permission, তারপরে পেন ড্রাইভে পাঠিয়ে দেবে। আর ওই usual condition not to tamper, and in case of any violation, cancel.
Grateful.
Grateful, Lordship.
25.
We order an adjournment has been prayed for on behalf of the petitioner, though the learned advocate appearing for the state is present. Dismiss the matter before the next available circuit bench. না ওই যে একটা পাসওয়ার্ড ছিল ওটা কি এসেছে? না না ওই যে ম্যানেজিং কমিটি ছিল, other side নেই? Mr. Raman, your other side has come? Or password. Or you try your luck before the next bench, what can you do?
The order of transfer has been already complied, has been complied with.
All right, then get hold of Mr. Mishra and come. Chaudhary. Achha. You mention when he comes, Mr. Ghosh.
I am here, Millard. Once he comes, Millard.
No, you are here, we know whether you will be exactly here or not, we
No,
don't.
no, exactly here. Exactly. Here.
Yes. Next. So,
Madam, related to NDP. I was arrested, that date very much important. The 2nd January 2022, I was arrested.
Yes.
Now, my lord, in this case,
Then what happened?
Hon'ble was taken
Right.
on spot, so for the allegation is concerned.
Hmm.
And that was 10 for FSL, that is Hon'ble which was taken from spot to FSL on 25th January 2022,
When was the seizure?
22nd January 2022, after lapse of 24 days. And for that reason, I am saying, humbly saying to your lordship, the dates are very important. Now, much more interesting thing is that sample was received by the CFSL on 27 January. Now, kindly see your lordship. As the copy has been supplied to me, I got the opportunity to see the entire record. The certification of authentication was held on 16th February.
No, no, when was the, you said 22nd January was the
Case
seizure?
was initiated and sale was
25th January was, it was sent to FSL.
FSL.
Now FSL gave the report when?
That is not my contention. My humble contention. Certificate of authentication when done.
No, no, you said no, it was sent to
It was
FSL and
received
received.
on 27th.
Acha, receive, yes, why
It was
do you avoid
received on
that?
27th.
Very good. Now
Now
certification was when?
done on 16th February.
After it was sent for
It's a
FSL.
check that was sent from for FSL.
Is
That
it a
is
fact?
my contention. That is my contention.
My lord, page 75, 76. Sampling for inventory and which was sent 75, 76.
Which was on which day? Can you
Wait, sir. He will argue. Why you are pointing out?
Page
Why this
75
over enthusiasm? I do not understand.
pardon?
Page 75.
No, no, not
76,
a question.
first
Nowadays,
page.
advocates do not follow this
The,
decorum.
sampling, I'm with you. Yeah, already.
This was the
These
application.
are done on 2nd January and the sample.
No, page 75.
2nd January. Page 75, yes, ma'am.
2nd
Se-
January,
2nd
it
January,
was sent
Caesar
to the
done.
magistrate.
Caesar. Caesar.
Caesar was 2nd January.
2nd January,
Hmm.
my lord.
I don't follow
Then 25th January, it was sent for sent to CFSL.
It was your representation to the judicial magistrate was on 2nd January 2022.
Prepared, my lord. Representation before the magistrate is 14 January 2022. That is page 69.
Address করছো?
This is preparation.
I request
Preparation
you
was
to
made
allow
by
the
made on
52.
2nd.
Uh-huh.
That is 69 man.
69.
Seeking permission for certification of inventory. That is page 69. Seeking permission from
But if this is page 69 is from the commissioner to officer in charge of Bagdogra for approval of the journey to the staff who will be going for CSRO. 69. So that was on 14th January 2022. Now they actually went 25th January. No, you you show us that when did you apply for the certificate and when was the certificate granted? 2 dates.
but 14 January applied and the certification done on
Okay, Dida,
to
we will record your submission.
certification done
Done.
on 16th February. That is page 78.
Certification, forget about certification. Caesar was on 2nd January
2nd
2022.
January.
Acha, you sent for FSL on 25th January 2022.
January.
Very good. Now, when did you apply under
Yes,
section 52A2?
Yes, sir. Sixteenth day of February.
You applied on 6th, you are correctly checked up,
Yes.
16 January of pay 2022.
15 February it was applied. No, 15 February it was applied.
Page
And-
page
78.
78, very good.
And 16 February it was certified.
Page 80.
Page 8. 78 and page 80. ওখানে
So
আমার ভুল হয়েছে।
that is certified on 60, where that is which page?
16 February.
80.
80 page 80. Yellow.
Seven.
78 page 78 for application.
Application is fine, order দিয়ে যে একচারে 16/2 হবে অ্যাডভান্স নাম্বার, এই সার্টিফিকেটটা দিল কেন?
16 তারিখে 16 তারিখ
16 তারিখ কোথায় দেখলি? সেটা 16 সার্টিফিকেট 15/2 অ্যালাউ করেছে, 16/2 সার্টিফিকেট।
করে দিয়েছে কিন্তু ঘটনাটা হচ্ছে
ওই একই সেম ফ্যাক্ট।
সেম ফ্যাক্ট তাই জন্য এটা নোট করছে।
এখন এক্সস্টেড না।
আর এইটা পাঠিয়েছে এফএসএল কে 25 before the certification.
He was the sole person,
No, two accused persons.
2%.
Unfortunately, same as item number 2.
No, that we will decide. Were any antecedent?
No, madam. No such incident.
এটা শুনুন,
Item 2.
ওই আইটেম 2 এর একটা অর্ডার আমি পাঠিয়ে দিয়েছি সই করে। ওই আইটেম 2 এর অর্ডারটাই না, এটার কস্টটা
নামটা
টাইপ করে ছাপিয়ে দিয়ে আমাকে পেন ড্রাইভে দিয়ে দেবেন, কারেকশনটা আমি করে দেবো। হ্যাঁ বলে দাও।
Application for certification made on February 15, 2022. Certified by the learned judicial magistrate on February 16, 2022.
It is.
Sent for sampling before the FSL on January 25, 2020.
ও না, ওটা কেন তুমি একটা অর্ডার দিয়েছিলে?
হ্যাঁ
মৌসুমীর অর্ডার,
হ্যাঁ
হ্যাঁ তুমি সেম অর্ডার দিয়েছো। ওইটা কত নম্বর বলো তো?
item 2
না আইটেম 2টা আমি দিয়েছি, তোমাকে আমি কারেকশন করে পাঠিয়ে দিয়েছি।
তাহলে আমি কোনটা দিলাম? আমি একটা দিয়েছি এরকম।
হ্যাঁ হ্যাঁ ওটা। এই মিস্টার, where is Mr. Ganguly? Which was your item 52A we granted?
Grant only.
হ্যাঁ,
24.
ওইটা হ্যাঁ 24টা ছাপিয়ে তার উপরে এটা নোটটা লিখে দেবে তাহলে। তো ওইটা বসিয়ে দিলেই হবে, ডেট গুলো।
আপনি পৌঁছে দেবেন, আমি যাবো না।
কে নিয়েছে? আপনি নিয়েছেন?
না ওই
লাস্ট কি লিখে? 17 তুমি ডেট অফ সিজারটা বলেছো?
ডেট অফ সিজার হলো January 2, 2020।
আর হ্যাঁ সিজার এফএসএল এ পাঠিয়েছে 25 ওটাতে কত দিয়েছিল?
খালি একটা একটু ফ্যাক্টসটা ডিফারেন্ট ছিল মিস্টার ব্যানার্জি যেটা ক্যালকুলেট করলো।
I think
ওইটাতে
we have
30,000
given 20,000 sheet. And what is the jurisdiction? You will remain within the jurisdiction of
Bagdogra police station.
Bagdogra police station. ওটাতে লেখা আছে নিশ্চয়, শুধু পুলিশ স্টেশনটা বাগডোগরা, ম্যাডামের যে অর্ডারটা আছে।
If you apply.
Yes, next.
Malad, other side is
Here, yes, ওই fixed ওইটা ডাকো অ্যাপিল।
65 and 63.
Lord, I am praying, Lord, let the matter be placed before the next bench, Lord, the paucity of time. Your Lordship, to desire.
65 and 66.
You want new faces to hear the order?
My Lord? No, 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 that is not.
তাহলে Mr. Raman, go before the next bench.
But his petition particularly, nothing remains of his.
Have you joined?
Yes,
He has already joined.
I have complied with the Lordship's direction.
Any
Lord.
problem?
My Lord, I have taken.
Nothing remains more of his appeal. That
No,
may
no.
kindly be disposed of.
Oh, my Lord, I have.
His prayers are already become
No, no.
redundant.
No,
No, no, we will record you have joined. So there will be no break-in service.
yes, no, Lord, the break-in service is not the only issue, my Lord. Because your Lordship, my Lord, directed me, I have obeyed with your Lordship's order.
Very good.
Now, my Lord, the question here is, my Lord, my right to constitutional remedy, my Lord, has been taken away from me, my Lord. So on that point, my Lord, I need some time.
Right to
Constitutional remedy, my Lord, because even I have joined, my Lord. My Lord, my Lord, I need a liberty, my Lord, to challenge that order, my Lord, before the appropriate bench.
next circuit করে দাও। Both the matters next circuit. রেখে দাও। তাই না? Order to be clear. কি বলছো? আচ্ছা ফাইলটা দাও। Which is your matter, Mr.
My Lord, 65.
65, man. Already exhausted.
অর্ডারটা ভুলে গেছি। লোকটা কোথায়? এইটা
Yes.
Mr. Chaudhuri, learned counsel appearing on behalf of the appellant submits that he has joined the transferred school in issue, full stop. Mr. Rahman, learned counsel appears on behalf of the state and submits that the appellant has been allowed to join the school in issue, full stop. Next. A prayer is made on behalf of the appellant. A prayer for adjournment is made on behalf of the appellant, full stop. Such prayer is considered and allowed, full stop. Let the matter appear before the next available circuit bench, full stop. Serve of all.
Grateful.
দাঁড়ান ওখানে অ্যাপেলেন্টটাকে দেখি by the managing point.
Mr. Ghosh.
I'm adjourning this matter as
Yes,
we are adjourning this
well,
matter.
It has already been dissolved. The administrator has taken charge.
Administrator taken, sir.
Yes. So no point pressing it on a Wednesday.
Then let there be a happy ending. We dispose of both the appeals on this. What we- Mr. Chaudhuri, how long you will fight? How long will you fight? No, today, what is the fact situation? You have complied with our order.
Yes.
You will not suffer your any prejudice regarding that.
Yes.
Now, the point which you are arguing is that I didn't get the time to challenge the order of transfer.
Right.
But you have made a representation for reconsideration of your order of
Yes.
transfer. So that if they do not consider, come.
It was also affirmed. I have already.
So very good.
But
Now, transfer order you have complied with, you have joined.
Yes.
Now, there is a representation you made to the authorities that reconsider my transfer.
Yes.
So if they do not reconsider, come again before the court.
It's a fresh cause of action.
Lord, my prayer for my representation was purely on a point of law. So Lord, that point, Lord.
আসুন
And Mr. Ghosh, what had happened, what remains in your matter?
Since this one is going to the
Administrator
next
appointed,
meeting, Milord,
finished.
the matters are together appearing, Milord, since long, let both of them go. Milord.
Well, let both of them be disposed of.
Mr. Ghosh, learned counsel appearing on behalf of the appellant, prays for an adjournment, full stop. Mr. Rahman, learned counsel appears on behalf of the state, full stop. Let the matter being MAT, let the appeal being MAT 148 of 2023 also appear before the next circuit bench, next available circuit bench, along with MAT 147 of 2023. Full stop, serve of all. একসাথে করে দিয়েছি ট্যাগ হয়ে গেল সেকেন্ডটা ট্যাগ হয়ে গেল ফার্স্টের জন্য হ্যাঁ 148 টাকে 147 এর সাথে ট্যাগ করে দিচ্ছি
আজকে তো কিছু নেই হয়ে গেল যা টাচ করার তো আমরা করে দিয়েছি অ্যাপ্লাই করবো আমরা মিষ্টি মিষ্টি বলে কমপ্লাই করে দেওয়া হচ্ছে আর কি দরকার ঝামেলা অ্যাডমিনিস্ট্রেটরটাকেও অ্যাপয়েন্ট করে দিয়েছে ও বলছে আমি আর কি করবো অ্যাপিল হ্যাজ Yes.
After the petition. Lord, mature love affair, my lord, has been culminated into the prosecution case.
সুন্দর বলছে দেখো
The relationship, my lord, has been objected by the, my lord, the parents. The petitioner, my lord, was offered to, my lord, solemnize the marriage that was initially.
What is the girl's age?
My lord, as per the FIR, my lord, she was, my lord, 13 plus.
And you are?
24.
My lord, 24, my lord. My lord, I have, my lord, another contention, my lord. My lord, I would like to request my learned friend, my lord, to hand over the case diary, my lord. My lord, kindly have a look on the judicial statement of the victim.
To that we will look. আমার নাবালিকা মেয়ে বললেন 2 তারিখে কিছু না বুঝলে বাড়িতে বাইরে আত্মীয় স্বজন। POCSO was added later on.
Lordship.
6 POCSO, my lord. This is the 164 statement.
His wife's sister.
Oh, how long you are in custody?
My lord, for plus 10 months. My lord, put that, my lord, kindly have a look on section 25 of the POCSO Act.
Yes, to that.
My lord, section 25 of the POCSO Act, my lord, may I read it out. My lord, subsection 1 says that if the statement of the child is being recorded under section 164 of the Code of Criminal Procedure, 1973, the magistrate recording such statement shall, notwithstanding anything contained therein, record the statement as spoken by the child.
As spoken by the
child.
Huh.
That was not done. It has been recorded, my lord, in English. That was not, my lord, the version that was, my lord, stated by the victim. It's a clear violation of, my lord, section 25.
Where is it is stated that statement must be in Bengali or in English?
No, my lord, that has not.
Version has to be stated.
Stated.
Not that if he has said Bengali, you have to write Bengali. Punjabi, you have to write Punjabi.
Lordship, that is right, my lord.
Then all the police officers must be having knowledge about different languages
Yes, my lord.
and magistrates.
It is my
It's a
presumption, my lord.
good point, very good.
It is my presumption that must not have been done, my lord, in accordance with section.
Where is the medical report?
Medical report, my lord, page 30. My lord, kindly see page 27. This.
Twenty-seven.
27 is the 161 statement. Highly corroborated with the 164 statement, my lord.
Ashok,
My lord,
the
presently, my lord, presently-
girl has been examined.
No, my lord. Lastly, it was.
I have been instructed
lastly-
that the victim girl is already married to someone else. So far, I have been instructed.
My lord, lastly.
So how that can be a ground for bail?
My lord,
If that marriage is also illegal because she is only 13 years.
13 years, my lord, at the time of, my lord, the lodging of the FIR.
Very good that
2022.
FIR was lodged on
Now,
FIR was lodged on
14 years, my lord.
11th October 2022.
Now, this is 14 years, my lord.
She is 14 years today.
Today, my lord.
Yes.
Now, FIR, my lord, that was objected.
Are you are a married person?
My lord, I am not married, man.
Huh?
Yes.
You're
Yes,
surprised.
you're a married person.
164 আছে তো।
Clearly, this is clearly in the 164 statement, my lord. And
You're not married.
Before I have been-
Also the present
before I have
application.
been instructed, my lord.
Baje. Hard dilan.
my lord, lastly, it was fixed on 20 August 2023 for examination of the victim.
20th August.
August, my lord.
She deposed.
No, thereafter, no update in the e-court services. my lord.
Achha. Mr. Misrol and the advocate appearing for the petitioner submits that there was a consensual relationship between the petitioner, who is presently aged about 24 years, and the victim girl, who is presently aged about 14
14
years.
years.
Stop. the victim, stop. The allegations leveled against the petitioner are unfounded. Stop. Charge sheet submitted.
Yes, my lord.
He has already suffered incarceration for about 110 months. And upon completion of investigation, charge sheet has also been submitted. In the said conspectus, further detention of the petitioner may not be necessary. Mr. Nag, learned advocate, state opposes the petitioner's prayer and submits that there are strong incriminating materials on record against the petitioner. A witness, she has been examined.
No, my lord.
Stop.
Lastly, it was fixed on 29.
The victim girl has not yet been examined.
Yes.
And as such, the petitioner's prayer needs to be refused. Having heard the learned advocates and considering the materials on record, particularly the statement of the victim girl as recorded under, statement of the victim girl, as recorded under section 164 of the code, the medical report, and the gravity of the offense, its ramifications and the extent of complicity of the petitioner in the alleged offense. We are not inclined to exercise discretion in his favor at this stage. Application dismissed.
Grateful, my lord.
Application dismissed. We are not inclined to exercise. We are not inclined to exercise discretion in favor of the petitioner, and his prayer for bail is refused. The application dismissed. Being ato dismissed. At this stage, I will tell you. That does not prevent you to come, na, Mr. Mishra. It seems you are not exhausted today. Why, you have good cases.
This is very much happy, your lordship.
Now you are not exhausted, na? You feel pain when such matters appear.
I am not on bail, but on the grounds of protracted period of detention.
Where is your report, Mr. Sarkar? We have asked you to come with a report.
I have the entire certified copy.
Dharan, yeah. You have not got it?
Lordship, sir, no report has come, your lordship.
Can you see the page number 18 and 19? Last I have missed out. I have already annexed the certified copy. Page number 18 and 19.
So bring the report, Mr. Sarkar. There was it.
Certified copy in P. Page number 18, can you see?
But this was already there in the record. What we have done? What you want to show?
Lordship, on court. Now, can you see your lordship?
We have sought for the present stage of the proceedings.
I have the latest order I have.
Where is that?
Page number 9.
Yes. 5th of August.
After that, the date is fixed on 29th 9. Now can you see your lordship?
The girl was 12 years.
Now can you see your lordship?
The wait, and you were around how many years?
60.
60. And you are in you are in detention for how
I
many?
am in detention since last your lordship. 2nd May 2022. And which are trying to confirm with your lordship in the state of case number 70.
17.
70. There is specific direction. Passed by the honorable court that relying the section 35.
what the court has said.
All the circumstances. And that was duly communicated. By way of evidence. Order itself is against the order number page of 18. When is the order page number 18? No, that is the order itself. It is duly communicated.
Yes. Where is the, where, now the victim girl has been examined?
So,
But
See,
I
today-
need a one instruction as because lordship earlier occasion I have
Sent.
sent, but no reply has come to us. So one day accommodation is lordship. Because of the allegations, lordship, I will, lordship, lordship. Allegation is serious, 164.
If the trial is protracted, we do not find that there was no internet from which we judge in that state. I don't know. But we don't know. Trauma is a little bit different, but in the other stuff. I know this is different subjects. Not today. Yes. Bring the report then.
On the 18th, he was present, but they were not prepared and CD was not there. So for the order is there.
18th of June.
18th of, 28th of June.
Mr. Bhomik, we have called for a report. Let it come. Yes.
Lord, I am appearing for the petitioners, my lord. My lord, the allegations are drawn under section
Who is
21.
against you? Who is Mr. Chakraborty? You are there. You are there. 29. Yes.
Yes, my lord. The allegations are drawn under section 21.
June, 9th June, rejected lordship.
Yes, my lord.
Coordinate page.
Yes, my lord, I'll take your lordship to that, whether I am entitled to bail at this stage or not. My lord, the allegations are.
Elaborate rejection order is there, lordship.
Show us the last order of rejection.
Yes, my lord, at
Page 14.
page 14. 14 and 15. It was rejected at the threshold, my lord. Your lordship.
You are wanting default bail.
Default bail. My lord.
Yes, tell us.
Yes, ma'am.
Do you have all the records as regards default bail when the application was made?
No, it is annexed with the.
Yes,
Kindly
Mr.
come
Pisas.
to page.
Is,
Kindly come to page 26, my lord, of the petition, my lord.
when did you find there?
20?
Yes, 26, my lord. 26 of the. My lord,
Yes,
that was the 179th day.
179.
Yes, ma'am. 179 day.
NDPS, it is 3.
Yes, ma'am, I'll satisfy. I'll satisfy.
180 days.
Yes,
na?
yes, yes. That was on 179th day. I was not produced. The case was though fixed for hearing, and the 179th day and petition for extension was filed by the investigating officer. 26.
Where do we find that?
Yes, ma'am.
Extend-
26.
Yes, 26 prayer in writing for extension of
Yes, ma'am.
MSA for further 3 months.
Yes, ma'am.
Then what happened?
That was preferred by the investigating officer, whereas my lord, the statute specifically says that it has to be, it can be only extended on the report of the public prosecutor, which has been considered by honorable apex court many a times, and it has been held that the report of the public prosecutor will contain.
Forget about that point.
Oh,
What outside that, what do you?
Yes, madam.
Application was
kindly see,
admittedly made.
yes, ma'am. Kindly see the,
Application was admittedly made within 180 days.
yes, ma'am. Yes, ma'am. Kindly appreciate.
What?
On what ground, my lord, the extension was granted? That was solely on the ground of non-availability of the.
To prefer criminal revision, sir. Why you are?
My lord, I'm taking your lordship to that.
মুশকিল যা হবে এটা বেল লাগিয়ে দাও।
It is. My lord, coordinate benches judgments, several judgments.
No,
my lord,
we are not on judgments. You tell us that why your subject matter is now admittedly time has been extended. Your argument, if I understand, is that first of all, that extension prayer could not have been made by
Yes,
the investigating officer. And second is there is no reason given in the order towards extension.
Yes.
So that is a good ground for you to go. Why you are breaking your head here?
My lord, kindly consider, my lord, even if.
Sir, what we will consider, we are on bail. Your bail application rejected on 23rd June 2023. That is subsequent to the extension of time for filing. For extending the period of news, because that was on 25th January 20.
Yes, my lord, that even in that case, my right has been wiped away or not, my lord, I'll satisfy, my lords.
That requires time, sir. You are Mr. Lakhoti. Huh? Yes.
Kindly come to.
Sir, this requires time. If you could have shown us 179, then no application file, we would have granted you. But the difficulty is you are now wishing to challenge an order before for which and
Yes, my lord. After this, within 5 days, I pray for a bail. Kindly come to the next
Time
page.
is not ripe enough to consider. The bail is not ripe. The statutory bail is not ripe enough to consider.
Don't make installment submissions. He's making submissions.
Kindly come to page 27, my lord.
I have already.
This has to be considered, sir. You will not.
It requires
not less
time, it will require some
it
time.
will require time. You also come with a detailed report that who filed it, what was the reason for the investigating officer to file. Why didn't you file at the instance of the public prosecutor? That is a good ground. And there are judgments.
That apart, my lord, kindly come to page 60, my lord. Your lordship has considered, even today. My lord, the case, the seizure was made on 30 July 2021. Kindly see the date when the FSL was received, contraband was received by the Forensic Science Laboratory.
Now,
37th.
Investigation charge sheet.
28 September 2021, after 2 months.
Now thereafter charge sheet has been filed.
Yes, madam. Even if the charge sheet is filed, that is what Bikramjit Singh versus Union of India says. Even if the charge sheet is filed in the meantime, my right cannot be wiped away. Kindly come to para 34.
Heard the learned advocates appearing for the respective parties.
Madam, kindly make it next circuit, madam. I will have.
List the matter before the next available circuit.
Obliged, ma'am.
You prepare a synopsis. This way, handing over judge won't help. You have to rely Vikramjit. You have to rely that there is another judge in public only at the instance of public prosecutor, investigating officer. You also take instruction. Yes, next. Who is your other side? Adjourned হয়েছে কতবার? কি সেকশন দেখি? No one appears on behalf of the petitioner and no accommodation has been sought for. Though Mr. Sarkar, learned advocate appearing for the state is present. Accordingly, the application being approved is dismissed for default. Hmm. 31. You
I am for the
there?
petitioner.
Yes, who is your other side? Who? Where is he? What are the sections? NDPS?
NDPS, Lordship, 41B violation, Lordship.
41B violation. You have the certificate code?
Yes, Lordship, arrest memo annexed.
Acha, password put it. Yes. Or not today?
Not today.
He's here.
He's here.
Password. No one appears on behalf of the petitioner, though Mr. Acharya, learned advocate appearing for the state is present. So this is the matter before the next available circuit. Next available circuit. You are there.
Actually, this matter was partly heard.
Why?
This matter was partly heard by this bench, and a report was called for regarding whether any witness has been examined in the meantime or not.
Sir, Chakraborty Malad will appear, Malad, he's on the way.
Who will have, do you have the report?
Malad, he is holding the report. Malad, the landed APP is holding the report.
What was the matter about?
Lordship, that co-accused are on bail. The allegation is that the adoption was given without following the procedure, and in lieu of money, 6.5 years on in incarceration. 6.5. In spite of Supreme Court direction that statutory period is over, but matter has not been concluded. Now, my instructions are that 2 witnesses has been examined after pressure of this court, and now 48 witnesses are left.
48?
8 witnesses are left, Lordship. Total 75 witnesses are there.
73.
74.
Total. And
73 total. 23 examined.
28.
28 examined.
Not this is the report, madam. I'm going to one copy.
Did they take any adjournment? No, it's up to you.
Is that
No, adoption. Now tell us the matter, just
Lordship.
remind us.
Lordship, the allegation is that the petitioner.
No, it was last rejected on 6th August.
6th August. 6th August?
No,
No, Lordship. I have never been before any Superior Court or
this is first time.
this is first time, Lordship. Other co-accused bail petitions are bail orders are there.
375.
370 sub plus 5.
That is.
That is 370 is.
So trafficking. 370 is trafficking, no?
Lordship, I humbly submit. There is
Where the offense involves trafficking of more than one minor.
now 370. If Lordship says 370. This is
370
sub clause. It deals with the mean trafficking for the purpose of what?
For the purpose of exploitation, recruits, transports, harbors, transports.
Now, the allegation is I have given
more than one?
yes, more than one is 5. I have given adoption. We have given, rather 7 accused persons are charge sheeted. Given adoption to children, babies, to the parents who doesn't have any issue without following the procedure and in lieu of money. That is the allegation, Lordship. So the mode of, if we take their allegation to be gospel truth, the mode may be wrong, the manner may be wrong, but the reason, but the cause, they are getting the babies to bring those babies as their own child. So is
why you are a social well-being organization?
Lordship. Exploitation is there or not, Lordship will currently consider.
Whenever you give a child in adoption,
Which
for
child,
which you have no authority.
which child, Lordship?
Child, that is
Des-
you must have procured the child.
Destitutes, no single complaint regarding before the police regarding that I have traffic, I am engaged in trafficking, not single complaint before the police. Now
7% were involved.
7% charge sheet.
And what is the no, they have been granted
No,
bail.
Lordship, I am coming. Lordship says page 14 first of my petition, Lordship. CRMDB 82, 3 cases were taken together. The order was first on 14 page 14. Manoj Bhumik, Devashish Chanda, and Shashmita Ghosh. Now here, Shashmita Ghosh was granted bail by order dated 10th February 2023, and the other 2 accused persons bail were rejected. Subsequently, sees page 21 and page 18. This Devashish Chanda and Manoj Bhumik, their bail were granted by order dated 8/5/2023 by a coordinate bench. Now, what is kindly see page 26. Juhi Chaudhary, her bail was considered on 8/7/2019 by the Honorable Apex Court. Now, sees page 28, Lordship, kindly. The bail of Sonali Mandal was refused by Honorable Apex Court on 22nd February 2023. Now, I would like to pray before Lordship to see page 29.
This is the Sonali is
Sonali
before us.
Sonali
is
Sonali
before us.
Mandal. No. Chandana Chakraborty is before us. And the co-accused, Sonali Mandal. Now, kindly see page 29, Lordship. Direction was given by the Apex Court to conclude the trial within 6 months from today. That is on the order was passed on 22nd February 2023. So 22nd August 2023 has been over to conclude. Now, Lordship, kindly, I pray before Lordship the folded hand to see the order dated 6/6/2023 passed by the trial court to see the manner of prosecution going on before the trial court, Lordship. Kindly see which start with the certified copy I have filed, Lordship. It starts with.
Yes, we are going through it.
Lordship.
Bojo. Plus one to Bojo.
So it was observed by the manner was observed by the Honorable Trial Court. But, Lordship, here, Lordship, I emphasize on this point.
No, very good, but Chandana is before us. Apart from that issue, what is the involvement of Chandana?
Lordship, that
how you are in parity with
main kingpin, my lord, kindly, my lord.
Give a copy to him.
Copy.
Chandana arrested first, my lord, on 18/2/2017. She is a running chairman of the agency, non-governmental organization,
Now, what is the age of the children who were given in adoption? What is the average age?
0 to 6 months.
0 to 6 months.
Newborn babies. All are total, my lord, kindly appreciate my report, my lord. Total 69 babies. Out
So
of,
why didn't
out
you-
of 71, 69 babies has been recovered.
From parents.
Now, how many witnesses are still remaining to be examined?
48. If,
Still remaining, my lord.
48.
Now, have they jumped the bail conditions? The persons who have
No.
been given bail, Mr. Chakraborty?
28 already examined, my lord, out of 73.
Very good. No, we are asking that the persons who have been granted bail, have they jumped any condition?
No. I have no. No, man. No.
So then, Mr. Chakraborty, why you are apprehending that this person will also flee away?
He's a main kingpin, my lord. I have voluminous city, my lord. I can satisfy you thoroughly, my lord. All the 161 statement, all the 164 statement of the original parents of the children, my lord. Everything is there, my lord. Trial is in well swing, my lord. And my lord,
But how can you avoid the regards put by the Supreme Court?
my lord, kindly
Have you
appreciate, my
applied
lord,
for modification of that order?
370, 375 is there, my lord. The maximum punishment is for 14 years. my
We
lord.
are not on that. You tell us, how do we overcome the order of Supreme Court, page 20?
My lord, but I know, my lord.
এই ব্যাপারটা করেছো? কিভাবে ওরা দিল?
6 days has been there.
হ্যাঁ,
Out of 6 months, 6 days has been done.
very good.
Including today-
You finish
today,
it
my lord.
with then you finish.
Kindly, but I'm just telling you. But maximum punishment is, my lord, 14 years. So half of the punishment is 7 years, my lord. 6 years,
6 months.
6 months has been over. Another 6 months, my lord, provided trial will be concluded, my lord. Kindly, my lord. Only 6 months.
Have you seen the observation of the court, the audacity of your witnesses?
Trial.
No, see the audacity of your witnesses. Witnesses said that I have to guard Abhishek Bandyopadhyay. That is why I couldn't attend the court. Huh? This is the statement of a police officer. See, kindly see the last paragraph of the order. Put up a petition on behalf of the prosecution state. State is saying. Mr. Chakraborty, what is happening? The last 6th of June 2023. See, Mr. Chakraborty, what does the magistrate record? Last 5. Further, I find that the next date was fixed on such and such for cross-examination of Shaugato Ghosh.
6.5 years, 28 witnesses.
Shaugato Ghosh. But a petition has been filed on Ato on behalf of prosecution, stating that due to movement of honorable member of parliament, Abhishek Bandyopadhyay, in the jurisdiction of PW 20. Oh, apart from that person, there is no other police officer. It's happening. Prosecution is good, no? Prosecution was not prosecution.
No, she's a very intelligent lady, my lord.
My lord, may I,
If she get well, my lord, rest of the trial, my lord.
may I make a
Proceeded, my lord.
submission? May I make a submission? Lord?
Now, has your Sৌগত appeared ultimately after protecting Abhishek Bandyopadhyay?
28 witnesses. Witness number 20.
My lord. Sogata Ghosh, yes, my lord. On 16/5/2023, the position has been completed.
16/5/2023. This order was of 6/6/2023.
On date total 28 witnesses.
Sogata Ghosh, 20.
Video 20 was 12/6 and 13/6.
Serial number 20, my lord.
Yes.
Serial number, not.
Video 20
No, no.
not able to turn up.
Yes, I'm. Before.
His sports order, lordship.
ও বলছে
On
হয়ে
12/6,
গেছে।
13/6, date was fixed, he did not turn up.
16/5/2023,
ছয় ছয় বলছে যে সৌগত আসতে পারেনি
12/6 and 13/6.
12/6/13
এখন 28 নম্বর
Mr. Ganguly, the Supreme Court directed,
To conclude
requested the court, requested the
Requested the
court.
Lordship, I mean,
thereafter, my lord, kindly see, my lord, kindly appreciate, thereafter, nothing unnecessary delay. By
When
the-
is the next schedule fixed?
My lord, next schedule fixed on, my lord, 14/9/2023 for evidence, my lord, for till up to 20 of it, 29. Last page, my lord, present status, my lord.
Lordship,
6 months, my lord, only 6 months, my lord.
Lordship, one line submission. The latest situation is that court was compelled to expel 3 witnesses, including the Sogata Ghosh. He did not turn up and court was compelled to explain the witness. The trial court lawyer is present and he has handed over the same. Number 2, Lordship.
Mr. Ganguly, then bring it on record. To file a supplementary affidavit. They have already filed a progress note. But we cannot finish up the matter. This is the problem.
Friday. No, okay.
Mr. Ganguly learned advocate appearing for the
My lord, just
Mr. Ganguly learned advocate appearing for the petitioner. Prays for leave to file a supplementary affidavit. Stop. Let such supplementary affidavit be filed within a week from within 2 weeks with a copy to Mr. Chakraborty learned APP appearing for the state. Stop. Pursuant to our earlier direction, Mr. Chakraborty has filed a report where from it appears that out of 73, total 73 witnesses, 28 witnesses had already been examined and the next schedule of date has been fixed on 11th of September 2023 and 14th of September 2023 for evidence. কি বলে filed a report, let the same be kept on record বলেছো তো? No, filed it, let a copy of the said report be handed over to Mr. Ganguly in course of this week. Stop. তারপরে ওটা বলো মিস্টার চক্রবর্তী যে যার থেকে দেখছি এইগুলো stop. In view thereof, list the matter for further consideration before the next available circuit bench on 18th of September, on 20th of September, subject to the convenience of the honorable court. Stop. On the said returnable date, state would file a further report as to whether the witnesses appeared on the dates as already fixed on 11 September 23 and 14 September 2023. Stop. এই রিপোর্টটা না ওনাকে একটা কপি রেখে একটা Yes, next.
My lord, I am for the petition. This case was partly heard.
Pardon?
Partly heard on 30 August. 2 days fixed for status report.
You don't have a copy, Mr. Chakraborty?
Yes, I have.
You want to make a Xerox of that?
No, madam.
ঠিক আছে। Yes, 34, you are,
My lord, partly heard on.
who is your other side?
I am for the state.
Where is your report?
My lord,
here?
report has not yet come.
My lord, I have submit all the. I have submit all the order sheet.
What was the case? NDPS?
No, my lord,
Poxo.
Boxo?
I am custody for 7 year, 3 months, 6 days. Already, only 2 witness examined. My lord, kindly see.
Why didn't you file the report, Mr. Chaudhary?
Well, a report was called for, my lord. Probably it has come also, but not yet reached me, my lord, in the office. My lord. Probably they have misplaced it. They are looking for the report.
My
Then
lord,
come tomorrow. Oh, tomorrow nobody is coming, no? Day after tomorrow. And Mr. Chaudhary, get hold of your report.
Yes, yes. You want the full one?
35, I am for the petition.
35, yes.
My lord,
What is the matter? Supplementary?
non-compliance of 52A and Mohalla judgment, my lord.
When have you given to Mr. Chakraborty? Supplementary evidence? তাহলে?
No, it's on record, my lord. It's a part of CD, my lord.
Let the learned advocate files a supplementary affidavit. Let the same be kept on record. Stop. A copy of the same has been handed over to Mr. Chakraborty, learned advocate appearing for the state in court today. Stop. He prays for an accommodation to avail necessary instruction. Stop. Please the matter for further consideration on 12th of September before the next available circuit bench, subject to the convenience of the honorable court. লোকটা কোথায় গেল?
My lord, can't it be fixed on Friday, my lord? Right, closing. I'm humbly praying, my lord.
Next. Yes. লোকটা কোথায় গেল?
My lord.
Who is for the state? ওই same order করে দেবে. An adjournment has been prayed for on behalf of though Mr. Mishra learned advocate state is. Yes. 37. Who is 37?
I am for the state.
What is this?
Lordship, this is a case of 376.
How many days custody?
370 days. Not Article 370.
Charge sheet,
Charge sheet filed, no charge framed. Charge sheet filed on Lordship 29/11/2022.
Again, consensual relationship.
No, Lordship, here there are certain tricky things. If Lordship sees the statement of the victim girl, which comes with a statutory warning, Lordship. It's a
No, we didn't follow. Statutory warning means
Means it's a very bad 164 statement. I do admit.
no.
She's a major. She's
24 years.
24 years, 25 years now.
24 years.
Yes, Lordship. But the statement is
Married lady,
no, not married lady.
not married.
Not married.
And you are never.
I am aged 55 years.
55 years.
Same locality. Now, Lordship, the allegations are very
Bad
serious.
allegations.
Yes, Lordship. I do admit.
Then you withdraw your petition.
No, Lordship, I have little submission. I kindly appreciate that. I'm admitting the allegation in the 164 is very, very.
Yeah, give just us. You are in custody for.
I'm in custody, Lordship. I was arrested on. Lordship, arrested on 12 September 2022.
Yes, tell us, Mr. What
Lordship,
is
now.
your point?
The allegation, Lordship, I've seen the allegation in the 164. But I may ask a question to myself. I may ask a question to myself. Lordship has seen it. In spite of the same, why I am moving the application? She's 5 months pregnant. Now, may I ask a question to myself? Does confidence of Lordships arise seeing the statement that this statement has been made by a person of unsound mind? In my humble opinion, no. Then, Lordship, why I am saying so? Come to page 11, Lordship, kindly. That is a prayer for adding 120B against the relatives of this victim girl. Why? Lordship, kindly sees para 3. As per confessional statement of the accused.
No, para 3 of your application.
No, page 11. That is the prayer of the prosecution for adding 120B criminal conspiracy against relatives of the victim girl. Para 3, starting with as per confession statement of the accused person Subhash Roy, son of such and such, leading to statement of the witnesses. It is found that an arbitration meeting was held on such and such regarding, the date is very vital, 29/8/2022, regarding the incident that happened between such and such, which was attended by the following persons, namely, the names are given. The said arbitration meeting and demanded amount of rupees 5 lakh, and the accused should marry the victim, also compensation. I also collected audio video footage of the arbitration meeting. Now, in this meeting, the relatives of the victim girl demanded 5 lakhs and a proposal of marriage, to which obviously this accused denied. And on the very next day, this case was lodged. She was 5 months pregnant. The parents could not even identify or realize that their daughter is pregnant. And on the very next day, the FIR was lodged. Lordship,
but she is medical.
I'm coming, Lordship. Had I given the amount, no complaint. Now, Similar type of allegation has been brought by the de facto complainant involving his daughter against another person in the year 2009. Lordship, I am giving the FIR. Here also similar type of demand was made, denied, and case was lodged, and subsequently it was acquitted, Lordship.
Against this person?
Against against another person of same locality. This lady. By the second, the father, the complainant. This happens, Lordship. Who pays the money? No complaint. Who does not pay? Complaint filed.
Is she medically disabled? Is she?
Her statement, Lordship, has seen, and in this case, the previous case, not mentioned that she is medically disabled.
Yes.
No. In our case, they have maintained that she is mentally disabled. But in the previous case, it has not been mentioned that his daughter is mentally.
No, in the complaint that was not.
No. The previous complaint, which was lodged by the same complainant involving the same victim, does not disclose that his daughter was medically, mentally disabled.
So that is why your custody is required to find out the truth of the allegation.
Now, Lordship, the police could have directly identified. Charges submitted. Police could have directly found whether I am the guilty or not to cross-match the DNA. It has not been done. Same type of allegation in 2009 resulted to acquittal.
DNA profile is not taken by the concerned IO or investigation agency. That's true, Your Lordship. But allegation is serious, my lord. 164 statement directly involved this petitioner, and my lord, kindly see the medical, page 45. Where it is written that she is 5 months pregnant.
I'm admitting it.
Page 45.
Any statement that she is medically disabled or
161s are there, several 161s are there. They are the relatives of the.
But pregnant, but no sign of any injury.
No, that's
5 months pregnant, and the incident is of August 2020.
If incident, the complaint was lodged on 30th of August 2022.
22.
Yes. That time she was 5 months pregnant.
This medical was on which date?
My lord, after lodging of complaint, my lord,
3rd September.
September. That is after 3 days of lodging of the complaint.
Recording হয় না, কমপ্লেন হচ্ছে 30।
মেডিকেলটা কি না?
What about the earlier complaint that is
That is not in the case diary, my lord.
I have given the copy, Lordship.
That is not.
Charge sheet was submitted. We have the copy of the year 2009, Lordship. We will get the same victim, same complaint against another person of the same locality, which fortunately resulted in acquittal.
ও এইটা কেন খুলছে না? এইটা হ্যাঁ। কন্যাকেও করতে চেয়েছে, What is the FIR number 109?
FIR number.
510.
2022.
My lord,
Where is that?
PS case number 510/2022. The present case which we are working.
Where is the FIR of that case? You enclosed it.
I did not,
my lord, in the
Lordship, in the envelope, because
No, no, এটা কোথায় বের করে দিয়েছো?
Lordship, in the case study, your Lordship will
কোনটা
find.
বের করেছো?
In the case study, Lordship will find.
No, no, in your petition, you annex the other document also.
after memo of arrest.
The earlier case.
Earlier case, I'm now filing it. And the present case is on the envelope.
হ্যাঁ, এইটা দুটো বের করলে দুটো গেল কোথায়?
এটা পেছনের পাতায় এইটা পেছনের পাতাটা জেরক্স করেনি এইখানে
This is not the one.
হ্যাঁ দিস ইজ দিস ইজ এইটা পেছনের পাতাটাতে এইখানে এই পেছনের পাতাটা মানে ওরা জেরক্স করে না।
But in FIR, my lord, defendant complainant stated that victim is mentally challenged.
27 মাস বলে দিয়েছে কারণ তার আগের দিনই 5 মাস ওয়েট করেছে।
সাত মাস থেকে সম্পর্ক কেন করেনি? সম্পর্কটা কতদিন
সেটা বলে
You are a married person.
I'm a married person.
ছেলে আছে মেয়ে আছে।
This is a totally false case, Lordship. The DNA profiling would have easily cleared, but that is the reason police did not even care to.
Now, they demanded 5 lakhs,
5 lakhs
in
from
the
me.
29th of August 2022.
And on the next day, the FIR was filed. That's because I denied. Had I paid the amount, no FIR would have been filed. And same type of allegation previously also the FIR I have given, Lordship.
That we are not.
No. So it's a continuing process, Lordship. So doubt is, Lordship, I will not enter the jurisdiction, Lordship. I'll attend day to day.
তখন 11 বছর ছিল।
The present application has been filed. Mr. Ganguly, learned advocate, appearing for the petitioner, submits that the petitioner has been falsely implicated. The allegations leveled against the petitioner are absolutely unfounded. Drawing our attention to the prayer made by the prosecution for adding section 120 capital B. You were the sole accused.
I'm the sole accused.
Subsequently added the relative of the victim.
Victim's relative was added.
Now, this was allowed. This was allowed.
This
Yes.
was allowed.
They were arrested and
Charges
subsequently
also
granted bail.
against that persons also.
So it's a conspiracy for taking money.
For prayer was made by the prosecution for adding section 120 capital B of IPC against the accused persons named in the said application. Stop. The said the such prayer was allowed and the said applications were such prayer was allowed, but the accused person stated therein had already been granted bail. That is your statement.
Yes, sir, after arrest.
After they were arrested. Stop. He further submits that a perusal of the said application would reveal that there was an arbitration meeting held on 29th of August 22 regarding the incident, and an amount of rupees 5 lakh was demanded from the petitioner. Stop. As the petitioner failed to deposit the said amount, comma, on the very next day, the complaint was lodged. That is on 1st of September, 30th of August.
29th August is the arbitration meeting, 30th August it was.
30th of August. Stop. In the backdrop of such sequence of facts, it is explicit that the petitioner has been. It is in the backdrop of such sequence of facts. It is explicit that the petitioner has been falsely implicated. Stop. He has already suffered incarceration for about
370 days.
370 days. And there is no possibility towards early conclusion of the trial. And then in view thereof, further detention of the petitioner may not be necessary. Mr. Acharya, learned advocate for the state, however, submits that the petitioner was that the victim lady was stated to be mentally disbalanced in the complaint lodged by her father. Mother. In the same, it was also stated that she was pregnant for 5 years.
5 months.
For 5 months, sorry. For 5 months. Stop. The contents, stop. Stop. The statement of the victim girl and the as recorded under section 164 of the code, and the medical report would reveal the direct nexus of the petitioner in the alleged offense. In reply, Mr. Ganguly submits that though the victim lady was stated to be pregnant, no DNA, no steps were taken by the prosecution for DNA profiling. So hardly learned advocates appearing for the respective parties and considered the materials in the case taken. Stop. Prima facie, the contents of the complaint and the statement of the victim lady as recorded under section 164, reveal inconsistencies. Stop. The medical report also prima facie does not corroborate the victim's statement. Bearing in mind the nature of acquisitions in the light of the arguments as advanced, and taking note of the fact that the petitioner has already suffered incarceration for about such and such days, we are of the opinion that his further detention may not be necessary. Allow 10,000 to CODTs one look.
If there's some conditions, your lordship.
Charge sheet has been submitted.
10,000. Stop. Where do you reside?
Dhupguri police station.
The charges have not been framed.
No. November 2022 charge sheet filed. No charge frame till now.
Charge not framed yet.
No, the petitioner shall not leave the jurisdiction of
Dhupguri police station.
shall reside within the jurisdiction of Dhupguri police station. Where does the lady reside?
Same police station.
Dhupguri.
Not in the jurisdiction of.
The petitioner shall not enter the jurisdiction of Dhupguri police station.
Good.
Where the victim lady is residing until further orders. He shall intimate the address where he would be residing immediately to the officer in charge of Dhupguri police station. Stop. He shall not tamper or influence the witnesses in any manner. He shall not leave the jurisdiction. Residing. He shall, however, he shall have to attend the learned court below on all the dates as specified for hearing upon obtaining permission from the officer in charge of the Dhupguri police station to leave the jurisdiction for such purpose.
Grateful.
Not to tamper such and such. Allowed.
Lordship, for that I have to enter the jurisdiction of the Dhupguri PS for obtaining permission. I shall not enter the jurisdiction of Dhupguri, but Dhupguri.
No. Entered the jurisdiction. Now, however, he shall have to attend the learned court below on all the dates as for availing such permission, the petitioner would be allowed to may enter the jurisdiction of Dhupguri. Only for availing such permission, the petitioner will enter the jurisdiction of Dhupguri police station. Yes, next. Pen drive party. 30.
My lord, service has to the VG has not been evicted yet.
The learned advocate, Mr. Pal, learned advocate appearing for the petitioner submits that service upon the opposite part upon the victim girl is not complete. In view thereof, list the matter before the next available circuit bench. The petitioner is directed to complete service in the meantime. Yes, next. About the 43 the decade of 39. 39. Just 39. Who is there? No one appears on behalf of the petitioner. Stop, list the matter. 39, you are there. 39 is passed over. Oh, no. Then
31.
39.
39 next cycle.
Tahle Mr. Rai learned advocate prays for an adjournment, though Mr. Chakraborty learned advocate present. List the matter with next cycle. Yes, 30, 40.
My lord, I am for the petitioner in this case, and I was supposed to file the Aadhaar card as the petitioner belonged to this Nepal. He was a citizen of Nepal, and I was supposed to submit the Aadhaar card of a person who is known to the accused and residing within the jurisdiction of the court. I have submitted to the public.
My lord, I want to hand over one judgment of this coordinate bench.
No, what did we ask that he would be residing within the
Jurisdiction of the Siliguri court. The person, the Aadhaar card is of a person who is a resident of Naxalbari.
One Prosenjit Ghosh.
You ascertain that person is genuine or not, you ascertain. You have given the copies.
Yes, ma'am.
Yes, my lord. One other copy of.
As the learned advocate appearing for the petitioner. What he cannot read also.
My lord, this is a copy.
Oh, you retain the good copies and give the bad copies.
No, my lord, But it is legible, my lord.
Oh. The learned advocate appearing for the petitioner has placed on record. What did we ask? Where you, what you have given,
I've submitted the
with
Aadhaar
whom
card.
you will reside?
Yes, my lord. I'll be residing with this person.
The learned advocate appearing for the petitioner has produced the details of the person with whom he would be residing in the event he is enlarged on bail.
Yes.
Taito?
Yes.
Stop. Let the said documents as produced be kept on record. Stop. Copies of the same have been handed over to Mr.
I am Mr. Pal.
Mr. Pal, learned advocate appearing for NCB in court today. Stop. He prays for an accommodation to avail necessary instructions. Stop. Please the matter before the next available circuit bench. Yes.
My lord, I am for the petition.
41 years.
I am for the state, your lord.
What statutory bail?
No, my lord. That is 52A, my lord.
What sent after
No,
the
my lord.
Before the
correctness.
before the certificate?
Yes, ma'am.
Give us the dates. When
My lord,
was the seizure?
On
Caesar made
15th.
on, I am sorry, Caesar made on 15th of
ये के
September
रखो ना।
2022.
वो जो मैडम एक जो रिकॉर्डिंग ऑफिसर আছে না সুরজিৎ বাবু কোথায় পালিয়ে গেল ধরো কোথায় পালিয়ে গেছে Yes, madam, why didn't you give a copy of that document? She just now appeared, your friend appeared just now in that pattern,
Yes,
that
sir.
Aadhaar card. You are also there?
Yes, sir.
Oh, so where is the document? Give a copy to the court.
My lord, I'm telling you.
Ah. Yes, কোথায় গেল ও দেখেছো?
My lord,
Caesar was on
Caesar was on 15th of September 2022.
above commercial quantity,
Above commercial.
15 September, very good. Application made on
Application made on 26th of 26th of September 2022.
Certificate on
Certificate on 27th September 2022.
now when did you send for FSL?
26th, your lordship.
FSL on 26th
26th.
of September. Means on the date of the application.
Yes, your lord.
এটা তো একটু অন্য হচ্ছে।
ওই একটা সিভিলের মামলা যেটা FSL এর এটা একটা মোশন
Wait. So you send it on, you are sure?
Yes, your lord.
Day on which you applied, you sent it. What was the recovery?
Recovery was 1.37 kg of 376 kg of brown sugar. 1.37 huge quantity. 250 grams are the commercial quantity. But I have flagged.
Now
the
you have
important
already
pages.
got the FSL.
Yes.
Huh?
Yes.
So
Got-
you resend the
No, no,
certified
no, no,
sample.
no, man. Which I have sent on 26th. Regarding that article, CFSL has been collected by the concerned investigation officer.
Very good, but the main sample will be with you.
Yes.
Certified sample is with, which has been certified by the magistrate.
Yes.
That sample is with you.
Yes. That is not sent after the certification.
The certification, no sample has been sent, my lord.
After certification, my lord. But after certification, no sample sent to the CFSL. My lord, I have flagged the important pages, your lordship. All the important pages I have flagged.
No, do we check or you have checked?
I have already checked, your lordship. Court can verify.
50 September. Application September.
Yes, that the second application for
order.
Date was fixed for correction on 27th. And the 27th, your lordship.
Certificate was given,
yes.
But the application was on
26th, your lordship. Well, in CFSL report also, court can see.
Certification is filed on 26th.
CFSL report also, there, my lord, court can see the CFSL report also.
What is your other point?
My lord,
You are in custody for how many days?
more than 340 days, my lord. My lord, page 13, my lord.
Charge sheet submitted.
With CFSL.
My lord, page 13 of my application, my lord. The FIR.
Yes.
The last paragraph, my lord. Page 13, my lord, the last paragraph. Fourth line. I took 20 grams of brown sugar from exhibit A as sample for examination and marked it as exhibit C. My lord, now my lord, come to page 15 of my.
What? Page 13,
My lord, page 13, last paragraph, fourth line.
Yes, sample for and marked it as exhibit C. This was not done with the certificate of the magistrate.
Yes, my lord. First, my lord, and the gram is 20 grams, my lord. 20 grams. Now, my lord, at page 15 of my application. The CFSL report. The last bottom, my lord, the description. In the description box. The said plastic packet contains 17.2523 grams, including plastic packet. The 20 grams reduced to 17. We are going to talk about it. Relying upon, my lord, Union of India versus Mohanlal, my lord, para 14 to para 19.
He was the sole accused.
No, my lord.
No, my lord. Total accused, three accused persons are there.
FIR name 3 and charge sheet 4. One
Who
has
is
already got
Jagadish
bail.
Mondal? Who is Jagadish Mondal?
He has got bail, my lord.
Who is he?
He is one of the accused, my lord. He has been named in charge sheet and he got bail from the court below on medical ground.
Yes, Mr. Acharya, what do you say?
Commercial quantity, huge.
এই শোনো ওনাকে দেখে দাও।
Date of seizure, September 15, 2022. A short photo, contraband substance above commercial quantity. Sent for certification on September 26, 2022. Certified by the learned judicial magistrate on September 27, 2022. Yes. FSL sent to FSL for
On 26 September.
Sent to FSL for
Sent to FSL
sent
for
to FSL
examination.
for examination on September 26, 2022.
examination of the circular. If you would have note 340 days in custody, charge sheet submitted. 340 days in custody.
Arrested on September 15th, 2020. 340 days in custody. Charge sheet filed in November 2020.
Charges have not been framed.
No, madam.
Charges not.
Satisfaction of.
বসিয়ে দেবেন।
ওটা বলে দিতে হবে।
Satisfaction of
Satisfaction of my lord. Learned Judge Special Court, Second Court, Siliguri. Under NDPS Act.
Within this 20,000.
20,000 each.
20,000 আর other conditions will be there.
Deeply obliged, my lord.
And if I was the lodge, then Matigara police station.
Matigara police station.
ওটা থেকে ছিল যে মাটিগাড়া বেরোবে না বেরোবে না।
হ্যাঁ, ছিল, বলে কিছু ছিল। Release করবে।
You will meet, attend the court below on and don't leave the jurisdiction of Matigara.
Correct.
হ্যাঁ? ওটা একটু নোট করে রেখে দেন তাহলে ওটা হ্যাঁ
And we'll meet the
ওই
officer in charge, Matigara police station once.
My lord, at the time of attending the trial court proceeding, I have to attend the jurisdiction of.
Yes,
I have to leave.
that permission will be recorded.
My lord, my.
Yes, next 42.
Deeply obliged.
42, who is there?
Jurisdiction of the Matigara police station except for attending the dates before the learned trial court.
Yes, lordship, violation of 52A, lordship.
No, my lord, in this case, I have sufficient.
Yes, lordship, first. Lordship, date of season, lordship.
All right, we hear it on Friday.
Lordship,
We hear it on Friday,
I have sufficient. in this case.
not today. Could it? 43 on the prayer. Who is for the state? Mr. Nag.
Lordship, what pass for it?
Next circuit. Yes, passed over. Sorry.
I'm for the state. I'm for the picture.
lordship, non-compliance of section 41B of CRPC, DK Basu judgment and lordship, section 60A of CRPC, lordship. No independent witness was present in column 10 by the raiding party, lordship. To the CR lordship to court advance judgment, lordship, the raiding party. Yes, sir.
This you have annexed?
No, lordship.
Yes.
Annex lordship, other judgment lordship on 41B lordship. This is a recent judgment lordship, court advance granted bail lordship. Raiding party member signature, put her signature.
All right, we shall check it up and come. Next day, not today. You take part here. Please take back the CD. What is your ground?
My lord, column 10, the.
Anybody's signature was there? Column 10 empty.
No, lordship.
That's not empty. The raiding party, one of the.
Raiding
person of
party.
the raiding party has signed in the column.
Reading part.
Raiding.
Yes, next 44. 45. Hey, you can part here the ground. Yes. 45, no one is there.
Lordship, makes it next circuit.
Adjournment prayed for
45 on for the state.
the state Chakraborty next circuit. Yes, 46.
Your Lordship, this case relates to 14A and 14C.
Where is your other side? Mr. Roy is there. All right, we take it up next day, Friday.
Lordship, one indulgence I am seeking. Two matters, that is 53 and 58. We got the immunity up to today.
Oh, yes, yes. Yes, 53.
And we have complied with.
Wait. Yes, 46, not today, next.
47.
My lord, I am for the petitioner.
Come next day, Friday. Yes, not today, 48.
48, I am still.
I am for the petitioner.
Yes, you will do it?
Lordship.
All right, not today.
CD is not.
Not today. On Friday, we will take it up.
49.
There.
Lordship praying for next circuit.
Who is for the state? Is come. Do same order for the next circuit, Mr. Bishar. What is your name?
Alok Shah.
Alok Shah. Yes, for 50.
Lordship, I am for the petitioner.
No, you want, you are ready?
Lordship, I wanted to do.
You want to do? All right. Who is your other side? Mr. Nag is there. What are the sections?
Lordship, make it not today, tomorrow.
All right, not today. এই শোনো, এই anticipatory bail গুলো আগে দিয়ে দেবো।
51.
Lordship, in this case,
Mr.
Lordship,
Ganguly, come on Friday.
Lordship, the police is here. The only the report has to be.
Oh,
submitted.
अच्छा, that 41 eh?
No, the forest case, they took a
yes, yes.
Liber to arrest, whether he has complied or not.
Complied.
He is here. Just see the report.
Who is the petitioner?
Mr. Chhabuddar is not here.
What it is against?
Lordship, second para. Following the honorable court's order, the petitioner general first visited my office on 3/9/20 and secondly on 4/9/23. But this is to inform the honorable court that his assistance towards the investigation was very poor and he did not show any cooperation. Thus, despite of two conclusive failure, I was unable to fetch any concrete information from him and would be helpful for the interim. The officer is present, Lordship.
We said not to arrest in the meantime.
And that is the reason they are not here. Officer is here, Lordship. That is the
No one appears on behalf of the petitioner. To order to that, Mr. Ganguly, learned advocate, has placed before us the report as called for earlier. Report of the range officer, comma, as called for earlier. Stop. Let a copy of the same be kept on record. A perusal of the said report. The said report appears to be adverse against the petitioner. However, as none appears today on behalf of the petitioner, stop. Release the matter for further consideration. On 8th, the personal appearance of the range officer is dispensed with. We did not ask him to come.
No, he personally came. If any queries that he could satisfy.
ঠিক আছে, করে দিবেন। এটা রেকর্ডে রেকর্ড 52
My lord, I am for the petitioner.
come tomorrow, Friday.
Okay.
53
Let it be fixed on the next circuit.
My lord, then not to take the cursive action, my lord. Then not to take any cursive action.
Notes, my lord, which I have already last.
My lord, I have handed over the judgment already on the previous day.
What was the issue involved?
My lord, the issue was whether the 430 is maintainable or not, if the section of SC/ST Act is applicable.
My lord, I have already submitted.
That is Atrocities Act.
Yes, my lord. Yes.
I have already supplied the judgments.
Let us see you come tomorrow. Today it cannot be finished. We can keep it in the next circuit.
My lord, let it be on the next circuit. My lord,
So
because
you arrest in the meantime, then what?
No coercive action, my lord, then I have no problem in next circuit.
No, Sheta we won't say. How can we say that?
Prima facie offense does not disclose against this present petitioner.
Yes, yes. All right, take it, let it be on Friday, let us see.
My lord.
Remind us, yes,
My lord.
53, who said report is
My compliance.
cooperated, cooperated. Ms. Das?
Yes, Lordship. Report, we have received the report.
I have also.
Wait na.
চলো না।
ছেলে পারা যায় না ছেলে দেখি দাও
Lordship, this is the compliance report.
কোন এই মানে মডিফিকেশন আর বেল যে কত থাকলে পরে বেল তো আর বেশি থাকবে না কত শোনো কতগুলি আছে বেল 9টার মতন নোটিং হবে না তুমি অ্যান্টিসিপেটরি বেলটা উপরে দেবে তারপরে মডিফিকেশনটা দিয়ে দেবে হ্যাঁ তারপরে বিল Mr. Bhomik, you tell us what was the matter?
Matter was, we had a lab affair. And so for the allegation is concerned, we took some obscene photograph and that was circulated. This is the whole of allegation.
Adult lady.
Adult. And for that, the lordship was pleased to ask me to hand over my phone.
Show us the that 164
Lordship.
and complaint that is complaint was that he has taken obscene photograph.
Lordship, the victim lady, she is the complainant, Lordship. In her complaint, she has stated that the accused person took some indecent photos and he circulated those on.
Very good, but how 376?
Lordship, Lordship, he was blackmailing, showing the photos, Lordship. He demanded money and Lordship, he was blackmailing the victim lady, Lordship. টাকা চেয়েছে।
My lord, for the affair is concerned, she is the ex-pradhan of a local Gram Panchayat. At that time, we interacted with over phone and subsequently we met each other and cohabited. This is the allegation in the FIR. That is page 9 of my application.
আমার সঙ্গে ফোনে যোগাযোগ করছিল আমাদের সাথে মাঝে মাঝে ফোন করে তারপর আমার সঙ্গে গল্প করে আমার এত কেয়ার আমি তারপর আমি ওর সাথে অনলাইন আমাকে যেখানে দেখে সেখানে চলে আমাকে
by pursuant to our earlier order dated 29th August 2023, Ms. Das, learned advocate appearing for the state, has placed before us a report of the sub-inspector, attached to Malbajar PS District Jalpaiguri. Let a copy of the same be kept on record. Let the same be kept on record. It appears that the petitioner, complying with our directions, met with the investigating officer and handed over his mobile. So, handed over, and there is nothing adverse against the petitioner, against the said in the handed over the stuff. And handed over, and that the petitioner is cooperating with the investigating officer. Stuff. Having heard the learned advocates and considering the materials in the case diary, comma, the nature of accusations and the possible extent of complicity of the petitioner in the alleged offense and his conduct, comma, we are of the opinion that his custodial interrogation may not be necessary. Accordingly, allow 10,000 to say. Charge sheet submitted, Ms. Das?
No, Lordship.
10,000 to stop. With the further going, meet with the investigating officer once a week till investigation is complete. Anticipated bill to not to tamper, disposed of. Yes.
Another matter is that.
Lordship, 58 is also there.
We are not escaping. Wait. এই তো হচ্ছে প্রবলেম, আমি যখন ঢোকাচ্ছি বুঝেই ঢোকাচ্ছি। নেক্সট তো কোনো চাপই নেই পান, তোমাদের কোনো চাপই নেই। ম্যাডামের রেকর্ডিং, আমার রেকর্ডিং, সবাই তো তোমার সাথে দেবো। আর জয়ন্ত কোথায় আছে দেখতে পাচ্ছি না তো। Yes, 54, 50 not.
Service has not been completed.
POXO, the learned advocate appearing for the petitioner submits that service upon the
Complainant.
Sure, de facto complainant or the victim guard.
Victim.
Opposite party to ki ami jani na. Service upon the say is not complete. Cake stated.
And for the state lordship.
Ms. Das learned interceptions on behalf of the state, please the matter before the next available circuit bench. The petitioner is directed to complete service in the meantime. Now, victim thakle victim লিখে দেবেন। Yes, 55.
Lordship, I am paying for a one-day accommodation.
Not today. 56. State who
Service not completed.
same order as 55. Mr. Nag is there for state. Yes, 57.
Milord, I am Petitioner Milord. This matter was heard on 31st August, Milord, and your lordship had directed me to appear before investigation officer on 4th September, Milord. I have appeared and complied your honor's order, Milord. And now my only humble submission, Milord, that I am absolutely innocent in this matter. I have full sympathy for the family of the deceased.
Acha, we have heard. Ashu, dao taড়াতাড়ি দাও। Mr. Chakraborty, learned advocate appearing for the state, has placed a report of the sub-inspector of police attached to Siliguri police station. Stop. Let the same be kept on record. Stop. A perusal of the said report reveals that the petitioner, in terms of our earlier direction dated 31st August 2023, appeared before the investigating officer and cooperated with him. Stop. Having heard the learned advocates, bole, and the nature and the materials in the case and the nature of acquisitions, comma, the possible extent of complicity of the petitioner in the alleged offense and his conduct, comma, we are of the opinion that his custodial interrogation may not be necessary. Allow 10,000 to share charge sheet file.
My lord.
To share one with a further condition that the charge sheet file.
No, my lord.
Me shall meet with the investigating officer once a week till the investigation is complete.
My lord, I undertake, my lord.
Till the shall not arguably not tampered, disposed of. Yes.
I'm grateful. My
Lord, 58, my lord.
58.
Oh,
Same things. We have complied with.
Lordship, kindly hear us for 1 second, Lordship. The accused has complied the order, Lordship. He has handed over his mobile, Lordship. But Lordship, we have strong objections. Lordship, we have strong objections. Though the accused has complied with the order, Lordship, we have objections because he circulated obscene photos of the victim, Lordship. He sent those photos to the neighbors of his village,
all right,
Lordship.
very good. We take it up on Friday. Don't arrest him till Friday. Don't arrest him till Friday.
Lordship.
Acha, Ms. Das, learned advocate appearing for the state, has filed a report of the sub-inspector. Sub-inspector attached to Rajganj police station. Let the same be kept on record. Stop. Release the matter for further consideration on Friday. Stop. The petitioner shall not be arrested till
Lordship, can it be fixed on Monday, Lordship?
Monday. We want to finish it off. Then Monday we will give protection then.
Lordship, Friday then.
You satisfy us, we finish it off.
Lordship,
Because we
Lordship.
passed an
We'll do the
initial
matter
day.
on Friday.
Release the matter on Friday. The interim order is, the petitioner shall not be arrested in the meantime.
So, Lordship,
Grateful.
one kind indulgence, Lordship.
Wait, anticipatory bail গুলো উপরে দেবে, তারপরে দেবে modification application, তারপরে দেবে bail, তারপরে jail. Yes,
Lordship, item number 71 and 77 are the legal service matters. They are languishing in custody for 10 years and 15 years.
You mentioned
bail
we
appeal in
kept it.
connection.
Who has been engaged? Legal aid services, any advocate engaged?
I'm for the petition, appellant, my lord.
You have been engaged. We
Yes, my
didn't
lord.
find any
So
endorsement.
item number 71 and 77, my lord.
Try your luck on
No,
Friday.
it is second, in the top of the list Friday, my lord.
Sorry, that-
Languishing in custody for more than
Wait
15
for
years.
2
my lord.
more days. Next circuit would be coming. Sorry.